assume she stays the whole meeting, right?
Yeah,
Yeah.
yeah.
And then she's gotta end the recording.
Yes, and you also have to be careful because she starts the recording. Corrales, C-O-R-A-L-E-S,
That's her last name or her first name?
last name.
And the first name is Kat, is that
Katerina or something.
Katrina or
Something like
K
that.
or C?
C.
Something like that. That word starts
Um,
with a Q.
That's what they do. I do remember that. So
And
you,
so the last name you think is Katerina? No.
you're Korea.
Cor-
I'll find it for you.
Okay.
I'll get it for you. Let me write that down. Cats. Actually, I think it's a K, because I would remember if it's a cat, like the cat.
Yeah, yeah.
Cat.
Yeah, it's just her name and like an extension or a phone number where I can reach her.
Well, she's all over the place.
Okay.
She's the one that does the BLCC meetings.
Yeah.
She's all over.
Okay.
Now, when you start doing your administrative stuff on your own,
Mhm.
he's gonna gavel in the ATF cases,
Mhm.
then he's gonna gavel out the ATF hearing,
Mhm.
and then gavel in ours, so then you can leave.
Okay.
And you have to, keep track of those times for your final minutes. Never mind.
We found her.
You didn't tell him?
Julie was, I thought,
Got it. Thank you, Jillian. The ATF.
okay, and then I'll get Tiffany out.
Yes, and then get Sam, Susan,
So Sam,
I mean, unless Susan wants to stay.
there's only one.
Yeah, I may stay, just so I can get the feeling.
Yeah.
You know, we
Okay.
just, we started off with about 10 cases, that's how many evaded.
They always do.
One case is KRZ Holdings.
What?
One case is KRZ Holdings.
Mhm,
Okay.
mhm.
Yep.
They have to remember. Gavels it in.
You guys ready?
Yes, sir.
All right. Good morning, everybody. The time is 9 o'clock or 9:01. And I hereby call this August Code Compliance hearing to order. Today is August 21st, 2024. For these hearings, we generally follow an agenda, a copy of which you can find outside. The first item on the agenda is the call to order. So we just did that. The second item is the pledge to the flag. So I'd like to ask you to join me in the pledge to the flag. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. Thank you.
Good morning.
Good morning.
If any person decides to appeal any decision made by the Code Compliance Special Master with respect to any matter considered at this public hearing, he or she will need to ensure that a verbatim record of the proceedings is made, which record shall include the testimony and evidence upon which the appeal is to be based.
Okay, the next item on the agenda is dealing with the minutes from the Wednesday, July 17th, 2024 hearing. I have a copy of those minutes. Does anyone have any proposed objections or modifications to the minutes as currently formulated? Sir?
I was supposed to have a ADA hearing,
Today? A-
assistance,
ADA accommodation?
yes,
What accommodation did you request?
hearing.
Are you-
This case abated, and he was contacted and emailed that the case abate.
So his case isn't going to be heard today?
Correct.
Well, sir, your case is not on the agenda for today. If you want, you can put your name on the record and object, but no, the case is not going to appear in front of me. Does that make sense?
Right.
Unless I'm mistaken.
Because it's resolved.
It's resolved.
It
yes, sir.
resolved.
Yes. it's-
Okay, that'll be on the record?
Sir, would you mind coming up to the microphone? And I just want to make sure that you're, if you can.
Hello?
Yeah, can you please put your name on the record, sir?
William Allen Fabricius?
Mr. Fabricius, it's my understanding that your case is not going to be heard by me today, and your name does not appear on the agenda.
Okay, but I'm an interested party.
There is no case in front of me, so there won't be any hearing. There are no interested parties. It's just not in front of me. I won't be
Okay.
hearing it.
Okay, how do I get a register of actions, or will the minutes be available and constitute a register of actions?
I don't know what you
Or
mean,
docket? Or a
but
docket?
the reason why I'm addressing you now is because you've made a request for an ADA accommodation,
Yes?
but your case isn't going to be heard today, so I just wanted to let you know that's why there doesn't appear to be any ADA accommodation, because you're not going to appear in front of me. The county's not pursuing action against you, and I'm going to go back to the rest of the agenda to deal with everyone else today.
Okay, thank you, sir.
All right, thank you. All right, so regarding the minutes from July 17, 2024, are there any proposed modifications or objections? I don't hear none. I have none, so I'm going to go ahead and execute those minutes. And the next item on the agenda is the staff update.
Staff update, abated and continued cases are listed out front.
Okay. All right, so regarding the cases that we are going to hear today, again, they are on the agenda that's posted out front. I'm going to make a brief opening statement, and I'd like to ask for you to pay attention because some of what I say is probably going to be relevant for your hearing today. Good morning again. My name is Christian Waugh. I'm a licensed Florida attorney acting as what is called a special master. That's a fancy title created by law, but all it means is that Citrus County has hired me to preside over your hearing. What I'm going to tell you during this opening statement applies to your hearings, so I'd appreciate your attention. When your case is called, please come forward. You will be placed under oath. If you are appearing at a hearing like this for the first time, the county will call the case, and I will allow the county to present its case. You will have an opportunity to cross-examine any of the county's witnesses, and then you will have an opportunity to present your case regarding the alleged violation. That will be your opportunity to present evidence and to make legal argument. It is important that you take your time during this process because it is likely going to be your only chance to make your case to me. I will also ask whether or not you are contesting the violation. In other words, if you're arguing that a violation actually exists. If you do not contest the violation, I'll assume that a factual basis for the violation exists and just ask you how much time you need to fix the violation or to work with the county. This will help save time for yourself and others, but you are by no means required to do so. If you oppose the case or simply want to be heard, you have that right. At any time during the hearing, I may have questions of parties, witnesses, or staff. Before issuing a ruling, I will ask if there are any members of the public who wish to speak, and if there are, such members of the public will have one opportunity to speak per case. Such right to speak is not unlimited, and public comment should be focused on the case and made as briefly as possible. Although persons may be upset or even passionate about what they have to say, all witness testimony, including from the public, must remain civil, and you should not interrupt other witnesses, parties, or attorneys. In most instances, if you are found guilty of a violation, the law requires that I give you a time to comply before the fine begins. You must fix the violation by the date I give, or the fine will start to accrue for each day that you remain in violation. So, for example, I may find a violation has occurred on the property, give 30 days to fix it before a fine starts, or 60 days or 14 days. That's how that normally works. But the law does allow Citrus County to impose the accrued fine as a lien on your property. The county has the right to foreclose on that lien or seek money judgment against you after the lien has been recorded for 3 months. I encourage anyone here who has questions about their rights or remedies to seek their own legal counsel. In all cases in which I find that a violation has occurred, I will impose all costs required by county law. I incorporate these into all of my orders as standard provisions. If you bring your property back into compliance with the code during the time that I allow, that cost will remain minimal. But if you do not timely fix the violation, you will be responsible for additional costs, as well as the cost of the lien imposed. Although it has only happened a few times in my years as a special master, I may continue your case if I find a need for further evidence or argument. Are there any appeals of orders to?
No, sir.
Ladies and gentlemen, you do have the right to appeal any order that I make today as provided by law. Thank you.
First case on today's agenda, KRZ Holdings LLC, case number 2023-1357. Licensing Compliance Officer Keith Garner, page 20 of your agenda, expert on the case, building official, and director Samuel Costa.
Mr. Zarilla, do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Thank you. Can you please state your name for the record?
Kenneth Zarrillo Jr.
Thank you, sir.
Yes, sir.
And sir, just for the record, are you an officer or owner of KRZ Holdings?
Owner, sir.
Okay, thank you. Good morning.
Good morning. Keith Garner, Citrus County License Compliance Officer, case number 2023-01357. Chapter 18, Article 1, Section 18-8A, obtain after-the-fact permits for all construction and modifications, Citrus County Code of Ordinances. Address 1520 South Suncoast Boulevard, Homosassa, 34448. Property owner KRZ Holdings. Good service via signed certified mail receipt. I'd like to authenticate the following documents and request they are admitted into evidence. Photos taken at the initial inspection on April 15th, 2024. Corrective action inspections on May 29th, 2024. And photos taken at my pre-hearing inspection on August 20th, 2024. Exhibit B, copy of notices of violation, copy of notices of hearing, pre-hearing order, copy of continuation letters, and copy of the certified mail return receipt indicating good service at the address.
Now, sir, normally, and this is useful for folks to know, usually in these hearings, when he's trying to propose that these photos and documents become evidence, so I'm going to ask you to take a look at them and let me know if you have any objection to them being evidence. Well, I mean, I think the public is able to make a request for accommodation as well, I mean, unless I'm mistaken. So, is there anything?
Okay.
Since the public does have a right to be heard on
This is all stuff we've
hearings.
asked for, right? Yeah, you're fine. You're good, sir.
Okay. And while they're looking at those, I'm just curious, are you
Sure.
contesting whether or not a violation has occurred?
No, and I do
Okay.
apologize. The first notice that we got, we were in Arizona for 3 months, so I didn't get the notice until it said, hey, you have a hearing. We started right away when I got the notice of this.
Okay.
Which I guess we were a month
Okay.
already behind.
All right. I mean, if you're not contesting a violation, I mean, I'll want to know and I'll have to hear some more details, but thank you. All right, without objection, they're evidence. But how much time would you need to work this out?
Sure. So the only thing right now that they're waiting on is for the flood review and the mechanical review. I know they're having a little bit of issue uploading to the site, but 30 to 60 days.
Let me turn to the county. So he's not contesting whether or not a violation has occurred. I
Correct.
need to look at this in order to figure out how much time is reasonable to allow. But
Sure.
have you heard anything you disagree with so far?
Just the permits are in the building being worked on, and
They've
the,
applied for the permits.
correct.
Yeah.
And the use of the building being used as a public space. I
It
don't
is
know if
being
that's-
used as a public
right, I
space.
don't know if that's been permitted.
Are you saying that currently it's being used as a public
Correct.
space, but there's unpermitted stuff on there?
Correct. And the
Okay.
use of the building being used as public space, because it
Okay.
was prior a warehouse.
Okay. Are you trying to have it not be used while this is pending?
No, nothing with that. It's just they need to permit the use of the building so that it's correctly.
Oh, I see.
done.
So it's
Right.
not just an after-the-fact permit. You're saying there needs to be a permit for the use.
Correct.
Is that before me today, the use issue?
It's part of modifications to the building, yes.
Okay.
I wasn't aware of that.
I wasn't aware either, but let me just look at the code section.
And just for what it's worth, so that front building wasn't the warehouse, right? So only the warehouses were the buildings behind it. That was always like
Okay.
that was always a
Okay,
regular
and
office.
that's all I was seeing in
Yes,
there,
sir.
but I didn't know what was
No,
changed in there.
yeah, all the warehouses are the ones behind there.
So we're talking about air conditioning units being installed without a permit,
Pretty much, right.
and you're thinking 60 days?
I just, only because I
Yeah.
don't want to
No, I know.
tell you 30 and then not
And
have
I
it
don't know
done.
how long this process takes. I guess, do you think 60 days is a feasible amount of time to go through the review, correct any issues with the permit, that kind of thing?
I believe that would be pretty fair.
I mean, I feel like that would be enough time, but I don't know how behind you guys, I don't know how busy y'all are.
I'd say 90, if he's having to deal with issues on permitted use.
Do you have any
And it could be a
immediate,
change of occupancy. Yeah,
okay,
It gets a little bit more involved,
I see.
yeah.
Do you have any immediate health, safety, sanitary concerns that would lead me to want to shut it down or something
I
like
have not
that?
been to the site, so I wouldn't be aware of any.
Okay. Does 90 days, so what I'm gonna do is by stipulation, and based on the evidence, I'm gonna find that there's a violation. But I would grant 90 days to correct the violation.
I think that should
I
be
think that's
more.
reasonable based on the type of violation we're talking about. And what's the county's recommendation if it's not brought into compliance in that time?
Citrus County Code Compliance Division respectfully requests the special master assess a fine of $50 a day, along with administrative costs to begin after the date you deem sufficient to abate the violation. And the amount was selected based on the actions of the property owner once they revised the violation, and asked that the respondents contact the License Compliance Division when the violation has been abated so the reinspection can take place.
Is there anyone from the public who wants to be heard on this case? And Mr. Fabricius, can you hear me okay? Okay. All right, then what I'm gonna do is I'm gonna find that there is a violation and order that it be brought into compliance within 90 days. If it's not brought into compliance in 90 days, then a fine of $50 per day will begin to accrue. And that's the lowest that usually they request, so.
Yeah, and I think they're getting pretty close to having it
Okay.
done. I apologize.
No, it's okay. All right, thank you very much.
Thank you.
Appreciate it.
Next case, Stephen A. and Dorothy J. Herold, case number 2024-688, Code Officer Cody McGuire. Page 12 of your agenda, expert on the case, Land Development Director Joanna Katu. Yes, sir. No.
And I see two cases here. Are they being brought separately?
Yes, sir.
Okay, all right.
Ma'am, do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yeah, we do.
Please state your names for the record.
Dorothy Herold.
And Steve Herold.
Good morning.
Good morning.
Good morning.
Morning.
Cody McGuire, Citrus County Code Compliance Officer. Case numbers 202400688, a violation of Citrus County Land Development Code Section 4002, site development without a development order or permit. Address is 2353 South Palm Beach Loop. Property owners are Stephen A. and Dorothy J. Herold. Goods service via signed certified mail return receipt and posting of the Canto Government Building. I would like to authenticate the following documents and request abatement in evidence. Exhibit A, photos taken during my initial inspection on April 22nd, 2024. Corrective action inspection on June 13th, 2024. Aerial photos taken from the property appraiser's website and a pre-hearing inspection on August 20th, 2024. Exhibit B is going to be a copy
Let me
of...
stop. So you said photos from the property appraiser's website?
Yes, sir.
You saved them on August 20th? Or was there a date on those?
What are the dates on your
They're
photos?
stamped.
From the
I'm just curious what he's saying.
from the property appraisers.
It just sounded like you were saying those were, the photos on the property appraiser's website were August 20th. I would find that hard to believe, but, yeah.
I think so.
I don't have a date.
Yes, you do.
It should be on there.
It's going to be July 20th, 2023.
Okay, all right, thank you.
Exhibit B is going to be a copy of the notice violation, copy of the notice of hearing, copy of the signed certified mail return receipt, and a pre-hearing order.
Okay. Now, ma'am, sir, again, what I ask you to do is to look through these documents and let me know if you have any objection to them being evidence.
That was on the 20th.
Yeah, and that's from your camera?
Yes, sir.
Okay. Yeah, let's take this.
Oh, this is 4/22.
Okay, yep. Okay. 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 Cool. I don't know what that is, but, okay. Yeah, it's just up in the front there. Okay. Okay,
This is 8/20. This is what he's showing.
yep,
It's recent.
and then the aerial.
Yeah, okay.
Okay. Yep.
Okay. And while they're doing that, is there anyone from the public who wants to be heard on this case, just so I know? Okay, thank you.
They appear to be all pictures of it.
Okay. All right, so then, if you would, Mr. Yeah.
Did you want to go through this as well?
Is this
We
what
have
I have
that.
here already?
Yeah.
It's the same thing.
Yeah.
Yes, sir.
Then I have it all, thank you.
Okay. While they're doing that, I'll ask you, now there's two cases, but this one is just regarding whether there's been, I guess, no development without a permit. Are you contesting whether there's a violation in this case? It's okay if you are, I just
Well,
want to know.
We're not sure.
Okay, that's fair.
We're not certain that what we did was development.
That's
yeah.
fair, I understand that.
Yeah.
So,
We weren't sure what exactly the notice was for. Now that we see the pictures, we
I
kinda
will,
get it, yeah.
then I'll let the county proceed. Hopefully, all will become clear to you and me.
Thank you.
And without objection, what's been proposed as Exhibits A and B are evidence. Please proceed.
Okay. I conducted my initial inspection on April 22nd, 2024, and observed the property had trees removed. While researching the property, I observed that there were no permits applied for or issued. The aerial photos from the property appraiser summary depicts a large amount of trees covered for the property before the trees were removed. I have had contact with the property owners on May 20th, 2024, in which we went over the violation for the tree clearing, the fill in the gravel driveway. He stated that the trees were removed from being diseased, dead, or had fallen, and then were cut up. The fill was brought in to fill holes in the back of the property from hogs tearing up.
What did you say about the fill?
He stated that the fill was brought in at the back of the property from hogs tearing it up.
Oh. Is it, okay. Is that it?
No. At that time, I stated that the fill covered the entire property and not just the back. And as of my final inspection on August 20th, 24, no permit has been applied for.
Now, before I turn to them to hear their side of, and maybe it's all accurate, where in these photos are there photos of the fill? Just so I understand what the county's position is, if you wouldn't mind showing me.
So it's going to be all of this?
All right, so it's this?
Yes, sir.
Okay,
And then all of this.
okay.
And then
Anywhere the
all of
light
Yes,
orangey
sir.
type?
Yes, sir.
Okay. What about, this is not included in that?
That would be the gravel driveway.
Okay, yeah, but you're not saying that's fill.
No, that's
I just want to make sure. Basically this on page
Yes, sir.
B12?
Yep.
Okay. Okay. 312, I'm sorry, 312. Let me just think about this for a second. All right, let me look at the code section. Actually, you have an expert.
I do.
Okay.
Joanna Katu.
Would you like to testify, Ms. Katu? Yeah.
292, land development. This is a CLR lot, residential, so coastal and lakes residential. It's about 0.4 acres in size. It should be vacant. We don't have any permit applications.
So I definitely understand how that would be relevant for the next case. On this case, is there any relevance to it not being vacant?
No, in that case,
Okay.
you're right. I misspoke. That should be
No,
for the
I'm
next
just
one.
curious.
But the definition of development, there is a material change, so this does trigger the development definition
It's both the tree removal and the fill
and the gravel, all three.
and the gravel.
Yes.
Okay, so the gravel was something that wasn't, all right, I think I understand the county's case. Okay. Do you have anything else, Mr. McGuire?
No, sir.
Does it make sense to you what the county's case is?
Sort of.
Okay.
We were, as far as tree removal, we'll start with that. Under the assumption, based on what we printed from the county's website, under the exceptions, that any trees that had fallen on their own, died from disease, we were able to remove or do something with those trees. And if we're misunderstanding that, it says under exceptions or exemptions. And that's all I have to go by. So there were anything that was done with trees all happened on its own. We had underbrushed the property. I don't think that's against the rules. If it was, we did it. And once we had underbrushed the property,
And what section are you looking at for the exceptions?
it was from your website.
Yeah, I'm just curious what
Citrus-
section you're looking. I've seen what you're talking
Citrus
about.
County Tree Preservation Guidelines
Yeah.
for
And that's-
residential property.
Does it have a number on the?
No, it doesn't. We just,
I think that's in Article,
yeah.
Ms. Katu, you're,
There was no numbers.
Article 5? Yeah, it is. Okay,
Yeah,
I got it.
I didn't
got
see
it.
any numbers when I got it. I just happened to, I had made
It's
previous bunch of phone.
5700-ish.
Yeah.
I think you're actually printing from a website that's not the county.
Oh,
That's
okay.
why I'm not able to cite you.
No, it's.
But
was
they
the
do have,
county's
so
website.
5715 has exemptions for tree removal.
Yeah,
It talks about tree removal on residential lots with
Yes.
one or more habitable dwelling units. It
Yes.
talks about tree removal, agricultural operations, existing rights of way, removal of trees that are fallen, irreversibly
yeah.
diseased,
Yes.
dead, or
Yes.
listed as invasive.
yes,
Proof of these conditions should be supplied to the land development director or his or her designee. Right.
yeah.
That's,
Agreed.
that's sometimes the rub, is that last
That
sentence.
little sentence you just made, right. And so we unfortunately didn't know to take pictures of a fallen tree. We had one tree that had come up and the whole root ball came out and left a pretty good crater-sized hole.
Which is one of the reasons why we put fill in to
That
even out the
side.
ground.
And in fact, we didn't think that that piece of property was even ours. There's an adjacent empty lot as well, and we always thought the line was up more toward the last tree that had come down. And once we realized it was there, if you walk on the property in that area, and then knowing it was ours, and we're applying for a permit for a house there.
We,
Okay.
we do have a current contract with Acme too.
Homes.
And the permits are submitted. We do have a septic permit that he just gave to us last week, so we do have permits in the works.
It should be
With
landing any
Acme,
time
too.
with the county, if that's helpful.
Actually, so Mr. McGuire, I guess do you have any evidence that the trees that were removed were not dead or otherwise fitting this exemption?
No, sir.
Okay. Do you have any proof that the trees that were removed were?
I
On a
do have
thumb
some
drive, we have
pictures on a thumb drive.
Besides your testimony, I mean, your testimony
yes,
is evidence,
yes.
but, yeah.
But
Yes,
we
we
do
do.
have a thumb drive with pictures, and they are time-stamped with
With the
location
address
stamp
and, yeah.
when we took them.
yes,
And they
time,
do
yeah.
show.
Of the trees?
The dead
Yes.
trees, yes.
One of the trees that
The
had
rotted
rotted in
and-
the corner was a big maple.
Why did you take the photos at the time?
Because after we had
yeah.
gotten the summons.
Cody had
took
mentioned tree
pictures.
removal, so we thought, well, wait.
But you still had the trees there?
Yeah.
One of them fell into the wetland. We just left it laying there.
I see.
And there was a big rotten stump. We had that removed. But-
Okay.
But the tree itself's still laying there.
And the one we were still like cutting up because that's what had uprooted and fallen.
Yeah, when Cody came, he saw the one tree that had been, the guy that moved it just moved the big pieces of tree and laid them in the back.
Do you
And I was
have a
talking about-
laptop or something that you
Yeah.
can display the
Yeah.
USB on?
Yeah, I do.
Okay.
Also, we had a wetland delineation done, and there's a report for that about the site. And we have, anything I could bring to talk about the site I brought. Hope it comes out.
I don't know why in the code section it says that proof of these conditions should be supplied as opposed to shall be or must be. I don't know if that's,
Yeah.
that doesn't,
Right, the Florida statute says that if you're, and that's what we default to, is that you need a landscape architect or a, what's the terminology, a tree arborist, an arborist, excuse me,
Yeah.
a certified arborist to certify it. So even if they have pictures, I'm not gonna be able to tell visually that that actually qualifies, that would need an arborist or a landscape architect defaulting to the statute. In this particular one, if they show me pictures, I still would default to that statute and say, okay, I need something from a certified arborist or
there are
landscape.
pictures that are pretty obvious
There
when
are.
something's dead.
There are, but I do default to that part of the statute that says they have to certify it.
Okay, well, let's see it. I mean, if it's obvious, it's obvious.
If I could ask Ms. Coutu a couple of questions while they're pulling that up.
Yeah.
And it
When
was,
tree-
Actually, hold on.
Sorry, I'm
Let's.
sorry.
No, the county attorneys do have the right to, I guess, examine their own witnesses.
okay.
When trees are going to be removed from property, do they need to send the certification or arborist information to the county before they're removed?
Absolutely.
Where does it say that in the code?
Because it's an exemption that they're doing, the exemption permit, I would not allow them to do it ahead of time. That is saying, I'm gonna qualify for this exemption, show me that I do.
I keep getting, just so the county attorneys know, I'm hung up on the should versus must right now.
Well, and in this case, we understand, but it's not just the tree removal, it's a number of things. So even if they do win on the tree removal portion, we still have three
Oh, I
other
agree. I'm not even dealing with those
options.
right now.
So-
Yeah. Yeah, so I mean, so in other words, what the county's, talking about is they're saying, okay, you're focused on the trees, but even if they win on the trees, there's still the gravel and the fill, and frankly, they're right.
Yeah.
But for our purposes, I want to be right, so we're going
Correct.
item by item.
Yes.
And first, we're going to address the trees.
Thank you.
So do you have
I do.
any photos of
Yeah,
the trees?
what do you want me to?
Well, the county needs to see this, and I need to see this. Everyone
What
needs
should I
to.
do?
So if you could flip it and
I don't know,
show
should I
me,
walk?
you're going to have to represent. Now, the photos that you're showing me are from the USB, correct?
Yeah.
All right.
And I'll leave that with you guys if you want.
We have advanced technology. Okay. All right. Okay. If you don't mind handing possession to an agent of the county, then okay.
That's why we brought it.
That'd be wonderful.
Yeah.
Boy, I'll tell you
And
what.
then the thumb drive will have to go to the special master at the end of it.
Oh,
so
that's for
you
sure.
won't get it back.
They anticipated that.
Okay,
So
just checking.
that's why they're on thumb drive.
Yep, thank you.
Yeah. And maybe I should put that in the pre-hearing order. I don't know if I put it in,
It
but
said
just so.
something-
I think it's there.
Oh, it
said
is.
something in the documentation about supplying a
Thumb
pic-
drive.
thumb
It's
drive.
crazy when people read
Yeah,
the
sorry.
pre-hearing order.
She also has the ability to put documents up there, we all need to look at it, that's something new
And
she
there are
added
some
after the
documents in
previous
our thumb
hearing.
drive.
Wow. And
You continued the case that was gonna be the guinea pig.
oh, I did. Well, that was because the county didn't object, I assume, but,
Files on there, they're just asking which one,
Oh, okay, there's a lot.
or multiple files anyway.
There's a bunch, they're all about the property. So, I try to label them to make sense. Go to one that says fallen dead tree, like something like that.
Documents.
Fallen. Right, yeah, it's a rotten tree. That's a dead rock. And then to make it bigger. But that's all over in the southwest corner of the property.
okay.
And that's, you're seeing the tree as it lays into the wetland.
Okay.
You can see how it's all rotted on the end.
Right.
There's another picture of the stump.
So you had that removed?
That's laying there.
Oh, it's still there?
I tried to have it removed, but he couldn't get it out of there, so I just left it.
Okay.
Oh, great.
At some point, did it fall? I mean, it was that was,
It did.
okay.
So if you find for me, here, can I use this? Here's the stump. Right here, make that.
Okay, is that still there?
That's still there. Now, if you look at it, you see this, hang on. This area right here where it shows the stump isn't whole anymore.
Thank you, ma'am.
That is what was, when the tree tree fell, it left a 3 or 4 foot tall
Mhm.
stump. It was diseased, and so when we had the guy out moving the tree, he said, hey, I'll just get rid of the rest of that diseased stump.
Okay, so a tree fell from that spot.
Yes, so what
Okay.
you saw was the cavity of the tree that was left, and then the trees laying in the wetland. We
Mm-hmm. Okay.
actually didn't do anything with the trees still
Okay.
laying.
All right.
There was another tree, I don't have a whole lot of trees because I didn't know to take any.
That's okay. Just, you have the right to show the evidence, so
Okay, and then.
let's go through it.
What's this right here? This is some of the wood that we had in the corner from the tree that had split, and we had to move it in the back, and I was trying to cut it up, and
It's split?
yeah, it actually split and fallen.
Okay.
I have a picture of what the tree looked like before it went. It kind of grew out this crazy thing, and the last big storm we had, it split the tree, so we
Okay.
just had to take it out. And that was this tree here.
Okay.
And that's what's left of it on the ground. It's not really a whole lot.
Okay.
I don't know what to give you guys.
All right.
Just took some pictures. And then, the one that was to me, was the one in the corner that rotted. That fell naturally. This is more pictures of the, same tree, where the top of the tree was rotted, some of the rotted pieces are there, and some of the splits, you can see that it had split. And I didn't know what else to get you guys, really. I tried my best. And here's another picture again. And you see they're dated with the address and the
Mhm.
date.
Mhm.
So you see when I actually took the picture. And you can see some of the pieces of the tree are still
Is
there.
that material still there, or has it been removed?
It's still there.
Okay.
Still there.
Yeah.
Okay.
Yep, it's still there. Then for our building permit, we mentioned, that up on the screen, I gotta move it over to this other screen. We went with, Acme Homes to have a, requested for a building permit, and he went in for the engineering, and, so this is what we paid to them for Acme Homes, and we mentioned we're gonna try to do that. We have, the wetland results when we did the wetland inspection. And in here, he has his introductions, he talks about everything. And he said site inspection, it says the subject site was not fenced in or gated. We're going to talk about it. No evidence of recent clearing, dredging, or filling was observed on the site.
Mhm.
This is a certified, I don't know if you guys know this company here, Environmental Consultants. It does a lot
They're
of work.
well-known
Yeah.
here, yeah.
Okay, so I didn't know, but he's who did the.
I mean, I'm pretty sure his office is right down the street.
Is it?
Yeah.
I've never met him because he always goes out and I'm not there.
And that's September of 2023.
Mm-hmm.
Yeah, so we were having all this done in efforts for the.
So you're saying this document is relevant for what?
Well, just it says he didn't see any,
Phil?
and when he was there, what we did put in on one side was not there.
Okay. I was gonna say, it does really look to me like
Yeah.
there's some fill, so I
On the-
wouldn't buy
correct,
that, yeah.
Yeah, no, absolutely, but just recent.
Okay.
But I just wanted to show that we were making efforts
Yeah.
to move forward and build. that.
Yeah, right.
And, oh, then I had, other pictures, I don't know if that's relevant, anything right there, really. It's not. What's this one here? All right, so this, the only reason I had this picture is, I don't know how to blow it up on here.
That's
Back in
okay, I
this-
can see it.
That's right, back in this corner, back here, you can actually, from the Google Maps, see the tree stump is right where the X is right there.
Mhm.
That was still there before
Mm-hmm.
I showed you where it was
Right.
down to the ground. Anyway,
Are any of the trees that are in this picture, have they been taken down?
so the trees on the right are not our property.
Okay.
Our property stops right like along that
Is that the tree that split near the stump, right
No,
where
it's
you
the
were
one-
just
oh,
were?
look, see right there, where the X
Yeah, that's
is?
what I'm asking.
That one.
That's
And you
the
can
one.
see it's in really bad shape there.
Okay, it
There's
does
a
look split.
Piece of some other cut-up tree the county had taken down, they left on my property when they cut it
Okay.
anyway, but that's what that piece of wood is back there.
Are there any other trees that have been taken down
No.
that are in this photo, besides the split
I
one?
don't doubt this one will probably fall on its own, we're really nervous about it, but no, what you see is here. So we had the property underbrushed there were so many vines, it was terribly overgrown with vines, the sun couldn't get to the property, and shortly after that, stuff was kind of falling on its own. It just, we had, like I said, one fell with the whole roof all came up.
Okay.
But there was a horrific amount of vines, and there's still some stuff in the far back end of the property that, back that way somewhere, where the trees are in really bad shape, but we didn't touch any of that stuff.
Okay.
Because that's all the wetland back there too.
Okay.
And I don't know if you need any other evidence of the fact that we're gonna have some building
Well, you,
done there.
you have, this is your opportunity to present what you wish,
Okay.
so, it's up to you.
Yeah,
But I've got three issues here. One is the
Go ahead,
trees, then the
yes.
gravel, and the fill.
okay. Might as well
So
just focus
I
on
feel
that.
like this addresses your evidence on the trees.
Okay, thank you.
Okay. I'm not saying I've ruled in your favor yet. I'm just saying I think that's relevant.
I don't, yeah, I don't have.
Are you gonna
any less
move
than-
these into evidence? Is it your intention for these to be evidence?
If they want them, yes,
Okay.
I'll leave the thumb drive.
Does the county object to the photos that are on this thumb drive being evidence?
I know he's said quite a bit, I just did not hear for each of the photos, who took the photo?
Some are from Google, others I took and I timestamped them. They're all timestamped with the address and the date.
Okay, and unfortunately, I can't see the date even from this distance
let
with
me
them
get
being
you-
that large. If you could
yeah.
just tell me the date that you took them.
Sure.
There were two dates on the photos. One was,
I don't know how to blow.
If you could just read it to me, I don't have to see it.
Okay,
Just-
it's April 28th, 2024, at 5:29 PM at, oh, that's the wrong picture. That says 2356, but tree stump here. It says 2350, same date, August 15th, 2024, at 8:22 PM.
you have two, so on the photos that you've presented, there are two different dates on multiple photos. So you have August 15th photos and you have April 28th photos. So
Yeah.
some are on one date, some are on the other date.
Yeah,
Okay.
I may have accidentally put it on. It's the same tree, we just had taken photos once and then taken them again before we came here.
No objection.
Okay, then we're admitting them into evidence by way of the USB, and what should we mark them as? I guess Respondent's Exhibit C, okay? All right, so,
The only other thing is these pictometry pictures from this county's website.
oh, so this is on the USB too, so we
Yeah.
haven't gone through everything on the USB?
No.
Okay,
This is
well
on
then let's do
here.
that before we admit it into evidence, all right?
Yeah.
I wanna be sure that we've gone through whatever is on
Right.
this USB.
These are dated by the county down in the bottom corner of the picture. I
Okay.
didn't put that date down there. So it says, down here, I'm sorry.
What is this a photo of?
It's a pictometry photo from your county website of an aerial picture. They call it an eagle view of some
Yeah,
kind.
is it the red outline?
Yeah,
That's
the red outline is the property.
Your parcel.
Yeah,
Okay.
my parcel, thank you. And, it shows the RV park there. You can see the gravel.
Mhm.
But you can also see the land like it was after we had, done all the work we did on it.
Okay.
And there's others, I didn't know how many.
Well, because you're seeking to
Yeah.
introduce that USB into evidence, before I can admit it, I have to look and make sure everything that is relevant is on there.
Mhm.
If there's irrelevant stuff that we don't want admitted, we'd have to remove it.
Okay, everything's the property pictures.
If you
like
don't
this.
mind, go through each one
Sure.
and tell us what it is.
This is an earlier picture from 2017. It looks like there's possibly more foliage, or a lot of it's just vines and all. I just took that because what you see from the air and what you saw from the ground were different things.
Can you go back to the 2022 photo?
Yeah, right.
And when did you buy the property?
2017.
Okay.
That's why I took that one picture. There's the 2022 photo.
So is that gravel on the front?
That's the gravel.
Okay,
That's the gravel.
okay.
Yep. And there's the same picture again with the RV sitting on it.
I think that's relevant. All right.
It's relevant today, but it's just another picture from 2023, just another view.
Mhm.
These aren't my pictures, they're from the county. website.
Right.
And another one after, on the 24th, after we had put the fill in that one area right there.
Okay. All right, I think that's relevant.
Yeah.
Thank you.
And just another picture without fill in it. And I think another picture from 2019, which again, shows a lot of, I put this one in because you can actually make out aerially all the vines. It was all vines growing on top of trees, from the trees to the ground, from the ground to the top of the trees again. And again, these pictures don't show you very
Probably
well
invasive,
if-
but,
how,
yeah.
how bad it was. Anyway,
Okay.
that's it.
Are these all the photos on the USB?
Let's see. Got the building permit, wetland results. What else did I? It's just pictures of tree preservation, soil test. I also have the soil test that was done, in case you guys wanted that.
I don't, unless it's relevant for whether or not you did or did not put fill in.
No, it was, it's
You
not.
tested the soil, okay,
It was for the building permit.
okay.
It was one of the procedures needed, so I threw it on there. 'cause-
That's the recent one from Acme Homes, because we have a contract with them to
Right.
build a house.
I think that's relevant for the next case,
Okay.
not this one.
Okay, fine. Okay,
So
leave
I'll
that on there.
conditionally reserve ruling on that,
Okay.
and
Okay. I was just trying to.
is that everything?
That's everything. And then,
I honestly, I've heard him mumble a couple things that didn't pop up.
Go ahead.
So just preliminarily, I would object to what I think was a wetlands something that I
Sure.
don't think
What-
is relevant.
I saw that, and it was relevant for the fill issue. I thought that wasn't that the report from the environmental
Yes,
engineer?
correct.
So
Okay.
when he brought it up, it talked about how in 2023, there was no evidence of fill. But they've also admitted they put fill in,
Okay.
so, correct, after that. So I think it's relevant for the timeline, I don't think it, anyway, so I'm gonna conditionally reserve on this specific one,
Okay.
okay? Is there anything else on this USB?
no, it all pertains, it's all the same, pertains to the same things.
Well, I just wanna make sure that we have actually seen everything on the USB. This is important for our record. I'll get over and look if I have to, I just would appreciate.
This off here, and this off here, which are not relevant to anything. All the rest to me are relevant because
Here's my question, have we seen everything on the USB?
yes.
Are you sure?
Yeah, let's look at these pictures. These are the back of the lot where there's more trees that are dying from the vines. I took pictures of what the vines were like that we had to deal with.
Right.
More pictures of the back of the property with more trees that are dying that,
Okay,
yeah,
all right.
same thing again. More of the same.
But we do need to see it if it's on the USB and it's being introduced to evidence. So
good.
everything has to be cycled through at
That's
least.
fine. So is that good so far?
If, yeah, right,
Okay.
yeah.
And, let's see, I think I clicked on it. I can get rid of these, it don't matter.
You say they don't matter, but I need to see everything.
Okay.
Yeah.
These were just pictures of storm damage on the property, where water
Okay.
flooded the property.
Why isn't there a date on this photo?
Yeah, because it was taken a long time ago when it happened. This is one of the past storms, and we just.
So
had
why
to
is this
take-
on the USB?
I didn't know it was relevant or not, that it
Okay.
was flooded in that area. So
Okay.
That's why I can delete it off.
Do you think the flood caused the disease or death of some of these
It very
trees?
well could have,
Okay.
yeah, because it was pretty, got pretty wet from, that whole area was pretty soaked.
Well, I think I
Here's,
could probably cut to the chase on what
Yes.
I'm gonna do in this case.
okay. Anyway, if
Yeah.
you don't want these pictures, that's fine, I can take them off of here. Otherwise, everything else pertains to.
Well, all right, so, trying to think, but do you have any other evidence?
No.
So it's this USB and the photos and the reports?
Correct.
What's the county's position on admitting the entire USB? Because now that we've maybe seen everything,
Honestly, half of the photos aren't relevant. I honestly don't believe they are. I haven't heard testimony that he's an expert as to how water affects trees, so he wouldn't have expert testimony to get that in as relevant evidence. And you've already addressed the documents, but I'd say about half of the photos I don't think are relevant.
I am going to admit them to the extent that it's the respondent's perspective, but frankly, it's honestly your burden to show how they are relevant. And I don't know that some of the photos are relevant, such as the, flood damage from a very long time ago. I don't know. But I also don't think it's going to affect how I think about the tree issue. So, and I'll explain that. So if you don't mind, I would leave the USB. Yeah, it's in evidence now. I'd like you to go back so we can continue.
Close this up.
And the county may have questions, but you can just leave it. If you don't mind, would you go back to the
Yeah, I will.
podium? The county, that's
Yeah.
in the county's custody now.
That's fine.
So here's I want to make sure I understand what you're saying about the fill and the gravel. I assume after you purchased it, you put the gravel in to actually be able to put an RV or something on there. Why did you put the gravel on?
For that reason,
Yeah.
we'll be able to park something there.
And I heard what Mr. McGuire said about the fill, and that's his recollection or notes about what you told him. Was that accurate, or why did you put the fill in?
On that area is where the one tree had come up and big root ball had come out, and we felt it wasn't safe to be, once we realized that was our property.
It was so uneven,
And then there was an area right behind it, was the hogs had come in, they rooted up terribly, it was awful. It was ankle breakers, so we just, was our purpose for that.
So what he said was accurate. I mean, yeah.
We
right.
did do that.
There is someone from the public who wants to be heard on this case. Ma'am, I only saw your hand. You're welcome to come up and tell us your name, take an oath, and tell me what your input is on this case.
We asked them to create a swell.
Okay.
Do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Please state your name for the record.
Sally Krasny, Krasny. Good morning. I am Sally Krasny, and I live at 2341 South Palm Beach Loop, which is the property directly south of the Herolds. I am the complainant to this case as to the fill and the removal of trees. First off, the trees were not diseased. It was so full of trees before the Herolds bought it that you could not see within 10 feet within the property. They have clear-cut stripped the property. I do have photographs to put into evidence because I don't know about things like this. I don't have time, date, stamps.
Well, ma'am,
on
regrettably, unless the county is presenting it as evidence, I can't take it as
But
evidence.
this is where it's affecting my property.
Well,
They're flooding my,
understand.
I'm sorry, okay, they're flooding my property.
Let me,
is what's
if you don't mind,
happening.
let me finish.
Okay.
So I appreciate that you've brought documents that you want me to see or to introduce into the evidentiary record. I don't believe that I can admit them as evidence. It's up to the parties. So if a party looks at them and wants to introduce them as evidence, that's on the party. I don't believe that members of the public or third parties have a right to introduce actual
I
evidence.
can't show my flooded property.
You can tell me. It's not going to be evidence.
It's not gonna, okay, but I
Yeah.
can show you these?
I don't mind that.
Okay, that's fine. Do I give them to you?
No, you can stand there and
Okay.
show it.
The first property I have, the first picture is from the property appraisers. It shows our property and the Herolds. You can see how much they have clear cut the back of this property. And this is a new picture. We put a pole through our fence to their property. We have a carport along this property line. It's a white building on the property line. At the front of the carport, the fill is 14 inches. It's a 20-foot deep carport, and at the back of the carport, it has gone to 20 inches deep, the fill. It continues on, as you can see in the property appraisers, they continue to fill 40 to 50 feet beyond that carport. So we are estimating it's well over 2 feet of fill that they have done. Mr. Herold said, well, we had low land there anyways, but our objection is that he did this without putting a berm or a swale in to prevent runoff to our property. And he did it without permitting. We have pictures of wood chips on our property, which is from his tree removal that has flowed to our property. And this is a date stamped one. The hurricane, you can actually see the water running from his property onto our property. And these are more of the date stamped ones that shows his fill is running to our property. These pictures here are the flooding we have. When we moved here 25 years ago, we put a carport, sheds, everything back there for storage. We would not have done that if it was flooding. You know, we have an acre of land, we have plenty of room that we could have put it. But we would not have done that, but in these pictures, I mean, we're underwater here. And this is April 3rd after a regular rain. This is not during a hurricane that we have. His what is it, the wetlands survey or something he has, that was done years after he started filling. Mr. Herold started filling this property 4 years ago. And we're talking multiple dump trucks. We're talking 8, 10 dump trucks at least. And so the survey that he had done as far as the wetlands, we were there when the guy came out, September of 23. That's 3 years after he started filling. So that's a very inaccurate survey that he put there. And our only requirement is that for him to remove this, everybody has the right to use the property, but so do we. And our requirement is for him to remove this fill that he has illegally put in. He has encroached onto the wetlands, and to have this done, engineered and done properly. And that's really what our biggest complaint is on this.
I appreciate it. All right. I mean, do you have anything else?
No, that's all I have to say.
Okay. Well, thank you, ma'am.
Okay.
Is there anyone else from the public who wants to be heard about this? I don't see any other comments. Before I turn, because you have a chance, I'll give you an opportunity to respond. What is the county's ask in this case?
A one-time fine.
A one-time fine. What is the requested fine?
$2,500.
Okay. So I want to give you the opportunity to respond, as you may wish, to the public comment.
So I know behind their property is very wet. They have a huge body of water back there. There's videos, pictures that if I needed to present them, I don't know if I have them immediately, but I could find them easily, that show water comes in from that backside and flows onto the property. So I'm not sure what they're talking about on the flooding. They have flooding. They've had flooding. During one of the storms, there was pictures where they had like a river going across the backyard.
Into our yard.
Into our yard. So I'm not sure, again, about all their flooding. I didn't know that was a question. We had the wetland survey done. We're not encroaching on wetland. I think that if you guys will read the survey, it's very complete from the company, and he made his findings. Well, that's why we did everything, trying to be within compliance and make sure if we were going to encroach on the wetland, we knew that for the building. Apparently, we're not going to, but the point is we did it just in case we had to do some more things with the wetland.
Okay.
I'm not sure what more I can say about that.
Well, let me tell you where I'm coming down on it. 3 issues here, and first is the trees. Before I saw your USB, I actually was going to rule in your favor on the trees. and the reason I don't want to make a ruling about the referral to the land development director, but what I'm going to find is that on that, you know, the reason why that section is in there is because if you don't provide proof to the land development director, then they don't know whether this exemption should apply or not. So this is just an attempt to keep people from clearing their sites of trees and using that as an excuse. But here, I'm not going to address that. Actually, materiality was going to be my issue. And I didn't, based on the county's case, find that it was a material change. You showed pictures going back several years where I can see, and you had good reasons for it. There are bad vines, there's other stuff going on. But it looks like there is a big difference between when it was purchased and the way it is now. So I think technically that's a violation. I think you've admitted, frankly, to the fill, which qualifies as, I know that, not everyone is aware of this code section before they do this kind of thing, but that is, and I have to say that the gravel is a material change. And part of the reason why the county has this section is because when things like fill go in, it can affect drainage. I'm not saying it did. I don't know the answer to that, but that's why it exists. So I am going to have to find a violation in this case. They're not asking for the max fine, and I am going to support the county in this. So I will assess a $2,500 fine, find that there's a violation. I'm not issuing injunctive relief. County's not asking for that. So that's that case. Okay?
Thank you.
Next case, Stephen A. and Dorothy J. Herold, case number 2024-423, 2024-818, Code Officer Cody McGuire, page 13 of your agenda, expert on the case, Joanna Coutu, Land Development Director.
Cody McGuire, Citrus County Code Compliance Officer, case number 2024-00818, special requirements for all accessory structures, a violation of the Citrus County Land Development Code 3102A. Address is 2353 South Palm Beach Loop, Homosassa, Florida. Property owners Stephen A. and Dorothy J. Herold. Good service signed, certified mail return receipt, and posting at the Canto Government Building. I'd like to authenticate the following documents and request they be admitted into evidence. Exhibit A, photos taken during an initial inspection on April 22nd, 2024, photos taken during a corrective action on June 13th, 2024, and photos of my final inspection on August 20th, 2024. And Exhibit B is a copy of the notice of violation, copy of the notice of hearing, copy of the signed certified mail return receipt, and a pre-hearing order.
So again, I'd like to ask you to look through these documents and let me know if you have any objection to them.
It's the same ones?
These are different than the other ones. Oh. Are they just for the RV then?
I think
Is that
that's
right,
what their
Cody?
case is.
Yeah, thank
Okay.
you.
Yeah.
Yeah.
Okay.
Mr. McGuire, wasn't there also a trailer that comes and goes on the property as well that would be part of your investigation?
It's removed.
Been since removed, yeah.
Trailer hasn't been removed yet?
It has been.
Oh, has the RV been removed?
It was, and it's back again.
Okay.
It was on our paper that we didn't need to have that removed until November.
Okay, so we'll get into that then.
It's on
Is
our
there
paper.
any, I definitely will want to hear about that, but is there an objection to what's been proposed as Exhibits A and B?
No.
With the exception of the trailer not being in the picture.
Well, that's fine. So the county isn't making a case about the trailer, correct?
Correct.
Okay. So I'll admit the Exhibits A and B as evidence, and please proceed.
Okay. On April 22nd, 2024, I conducted an initial inspection and observed an RV and a trailer on vacant property. On June 13th, 2024, corrective action inspection was conducted with no change. I have had contact on the property owners on May 20th, 24, in which we went over the violation. I stated the property had to remain vacant until there was a primary structure, meaning a house. As of my final inspection on August 20th, 2024, the property remains in violation and no permit has been issued, and the RV remains on a vacant property.
All right, let me make sure I understand your case. So you're saying that you had contact with the property owner and informed them back in May?
Yes.
Okay, that the property couldn't be occupied, or the RV couldn't be occupied?
The RV cannot be on the property.
Oh, it cannot be on the property?
Correct.
Regardless of whether it's occupied or not?
Correct.
Okay. And that's because it's an accessory use without the principal use being established on the property, correct?
Correct.
Is there any other testimony that the county wants to offer?
Yes, Joanna Coutu.
That'd be great.
No problem. I heard some testimony from the applicants that they've applied for the septic permit. There's no application for a building permit at this time. I'm a little concerned about the Acme Homes reference. This is not a mobile home area, but they do have some modulars.
It's
Okay,
it's
good,
going to be
good.
on stilts, yeah.
Yeah, but there is no application at this time.
You're
so
not aware of an application for a building
I
permit?
checked this morning. There's
Now-
absolutely none.
Now, if they were looking for a septic, would that be a building permit?
No.
Okay.
That is an entirely separate process with the state of Florida.
I gotcha.
Going to
Okay.
say he gave us.
Well, I'll let you definitely respond. I just want to make sure I understand where they're coming from before I turn to you. So this is fairly routine, okay.
And it's vacant, and there shouldn't be
Right,
anything
okay.
there, and, yeah.
All right, I understand. What's your perspective?
Our perspective is we didn't understand that until Cody brought it to our attention. He said he would send us documentation on it, we'd get a certified letter. We did, and we had 2 documents, and one of them we're talking about now, and he said the action must be taken by November 6, 2024.
So that's why we didn't move it.
So
Yeah.
Okay.
Says
that's
it
why we
right
didn't
here.
move it.
Well, let me look at the, maybe that's in my packet. I don't know.
Otherwise, we would have moved it.
We would have
That was an
moved
easy
it.
Okay,
fix.
all right, well, let's see.
And we apologize.
Sure enough. So it's just interesting. Hold on, let me think about this. Mr. McGuire, are you familiar? Have you seen this? It does say the following corrective action must be taken by November 6th, 2024. Well, no, I mean, what's your perspective on this?
I
Just a
unfortunately put the
mistake?
wrong date on there.
It was a mistake, all right.
Did you talk to him?
Yeah, but he said wait for the documentation, so I wasn't given any particular date or time.
I'm not, I'm gonna dismiss without prejudice. If it's not, I mean, I think, here's the thing, what the county, I'm not telling the county what to do, but I suspect this can easily be amended and revoked, you know what I mean? So I think that sure enough, as it stands, it's not fair to hold that there's a violation when you've been given until November. And I'm not going to find that there's a violation.
Thank you.
But they can easily just give you another
No,
notice of
and we'll
violation.
move-
And we'll move
listen,
Okay.
We're happy to just move it.
All right.
We don't want to have any strife here.
Okay.
We had to November 6th. We were waiting
we
for the
didn't
building
move it.
permit, and it's going to happen.
That's okay. It's
And then
dismissed
we
without
be within
prejudice.
compliance.
It's dismissed without prejudice, but I encourage
Thank
you
you.
to bring the property into compliance.
We will.
Okay?
Yes.
Thank you.
Thank you.
Next case,
Is that it?
Richard James
Yeah.
Sutton.
Thank you.
Case number 2024-957, Code Officer Julie Wilkinson, page 29 of your agenda. Expert on the case, Land Development Director Joanna Coutu.
Mr. Sutton, do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Good morning, sir.
Morning. Good morning.
Good morning.
Julie Wilkinson, Citrus County Code Compliance Officer. This is case number 2400957, special requirements for all accessory uses, a violation of Citrus County Land Development Code 3102A. The address is 8455 West Longfellow, Longfellow Street in Homosassa, Florida. The property owner is Richard James Sutton. I have good service via signed certified mail return receipt. I would like to authenticate the following documents and request they be admitted into evidence. Exhibit A, photos taken during initial inspection on May 22nd, 2024. Photos taken during a corrective action inspection on June 27th, 2024. And photos from my final inspection conducted on August 20th, 2024. Exhibit B, a copy of the notice of violation, a copy of the notice of hearing, a copy of the general pre-hearing order, and a copy of the signed certified mail return receipt.
Okay, sir, I'd like to ask you to take a look at these documents and let me know if you have any objection to them being evidence in this hearing.
No, I cut the fence down, but she already relieved me of that, I think.
Okay.
It was not the fence, it was just the gate.
Okay.
It was this much higher.
Okay.
But I cut it.
That's not an issue anymore. Okay.
And nothing can be seen from the street or anything. Next door here is a building ready to fall down and homeless people live in it.
Well, let me ask you this,
And they come
Mr.
and go, but
Well,
you know, and I guess they're supposed to tear it down, I don't know.
Well, let me ask you this.
I'm just wanting to put any money in this place anymore because of the neighborhood's not that nice.
Well, I understand, but if you don't mind, in order for me to hear the case, I want to make sure that you've looked through these documents
Oh,
and
yeah.
that you that I know what your objections are,
Yeah,
if any.
That's my fence, and that's a movable trailer that I have, it's legal, and I got my truck, I pull it around, and I was going through cancer treatments, and I got sick as a dog, and I didn't have, I got a thing where I bought a mobile home, and the guy sold me a mobile home that wasn't even his. And it was a legit
sir, hold on.
Sam's.
Before we get to
thing,
that,
you know what I
sir.
mean? But anyway, I lost that, so, and I got most of my money back.
Well, sir, it's just a,
But this guy was supposed to give me all the permits and
sir,
everything.
let me ask you.
Yes.
Can you please look through these documents? And
What,
when you're.
the pictures you're
Yeah,
talking about?
and when you're done, let me know if you
Pictures aren't
object.
documents, but are they? No.
Well, let me know if you object to them as evidence.
That's my place, yeah. That boat's going to the junkyard. Yeah, these are very new. 'Cause my Can-Am, it's right there. Yeah, that's my truck. I left the gate open. Yeah.
Okay.
Well, you know, I had issues going there with the neighbors, the next door. They burnt half my fence up, and then they had a shed on my property. I went through quite a bit to get where I'm at, and I kind of just run out of money and just didn't want to waste any of my time and energy when
Well,
you
then
thought
here's
I'd
what
be
I'm gonna
dead in
do.
5 years, you know?
Ms. Wilkinson, do you want to show these documents to the county attorneys?
I have no issues, but you know, if you keep finding me, I just got $42,000 worth of liens erased.
You did?
A letter of forgiveness, when I bought the place.
Oh, okay.
I didn't know all the liens. I was stupid. I just got out of the hospital. I had my leg taken off, then I got cancer. And I said, you know, this is just, I can't deal with it. I should get an attorney, I know. You don't, most attorneys don't know. Most judges don't like to talk to people. I know that. Lawyers,
I have
they
no
like-
idea,
I'm
and
not
I'm
a
not a
lawyer.
judge, but.
You're a lawyer.
Unfortunately,
And most
yes.
judges are lawyers, right? Yes, I know that.
Again, unfortunately, yes.
Uh-huh. But
All right,
I
so.
don't have the time and money to do this.
I've asked a few times,
So
but
I'm
I
basically
haven't,
in-
but sir, if you don't mind, I've asked a few times, but I haven't heard any objection to these documents. So I'm going to admit them as Exhibit A and B. And
Yeah,
before
but
I
they-
get to your version, I want to know what the county's case is. So first I want to hear from Ms. Wilkinson about what's going on.
Do they know what it looked like before I bought the place?
That's a good question, but it
Yeah,
may
I
not
have
be
no
relevant.
pictures of that.
It may not
I'd
be
like to show- make
relevant.
me
Sir,
look a
if
little
you don't
better.
mind, I'd like to hear what the county has to say. Thank you.
All right. On May 22nd, 2024, conducted an initial inspection and observed an RV on the property. On May 22nd, on the vacant property. On May 22nd, 2024, a notice of violation was issued for special requirements for accessory uses, which is a violation of the Land Development Code. On June 27th, 2024, I conducted a corrective action inspection and found that the property remained in violation. I have had contact with Mr. Sutton, who was confrontational. Mr. Sutton is aware that he cannot have anything on the property, as this is the third time that this violation has occurred on this property with Mr. Sutton as the owner. As of my final inspection, August 20th, 2024, the property remains in violation. My expert on this case is Land Development Director, Joanna Coutu.
This is a residential lot, low-density residential, mobile homes allowed, about 0.2 acres in size. We have no applications for development.
Do you have any recollection yourself, or have you done any research on the prior cases that I guess have existed?
I didn't see any prior
Okay.
cases with us.
Okay.
That just-
Well, it's
I'm
42.
not sure they were code enforcement cases.
I see. All right, thank you. And Ms. Wilkinson, can you explain what you said? You said it's the third time. Have you been over this with Mr. Sutton before? or-
Yes, last year I had a case with him, but it abated.
I see.
And then there was a previous case before I came on with a previous code officer that had the same case, which also abated. So none of them have made it to special master.
So if it abated in those prior cases, was there an RV at issue?
Yes,
And then the RV was just moved?
gone, yes. And in the last case that I handled that abated, there was also trucks, motorcycles, boats.
But they somehow
they
all abated?
They all left,
And
yes.
was there a fence at the time of your last case?
Yes,
Okay. And was there a fence at the time of the first case?
I do not know.
Okay. I mean, the fence looks good.
I had a different one.
Okay. Well, here's my question
I
then.
had Matt. Well, I guess he's not here anymore.
Yeah, that's my understanding. So, I mean, you understand what the county's case is then, correct? Because you've been through this before.
Yeah, well, see, I got all, this guy was supposed to do everything for me.
To
I
remove
gave him-
everything?
I gave him quite a bit of money.
To remove everything?
Yeah, to permits and everything. It was Sam's motorhome. I bought the motorhome off of him. I mean, it's right here. It's all, she wouldn't look at it, but I got it all. So I basically gave up, you know, then I got cancer and got sick. I said, hell with it, tell the truth. I'll be honest with you.
Is it possible to have an RV there as a place to habitate?
No, we would not issue a permit for an
Right.
RV outside of an
Okay.
RV park.
Okay, so in order to establish a principal use on this property, there would need to be a building permit for a regular, like.
Right, for a mobile home or a site
A
build.
mobile home or a site build.
Which I was doing, but
Okay.
it fell through.
But I don't think the
It's
county
another
has
legal
any,
case, I know.
I don't think the county is aware of any application for either a site built or a mobile home to be allowed there. Well, Mr. Sutton, here's the issue. This isn't different than the prior cases that they've taken up with you. You're gonna have to remove all your accessory
I
uses.
know, it's just kind of rough right now, you know what I'm saying?
How much time do you need?
6 months, maybe. I just recovered, man. I mean, I just get back on. I'm lucky I'm walking. I lost my leg in a motorcycle 4 years ago. I got it back on. I went to the VA wound care, stayed in there for 6 months and got out and then I got Mercer. And I'm 75, I'll be 75 next month. And I just, shit, I'm about ready to drop dead. And I got all this thrown on me and then, I bit off more than I could chew.
How long did it take to comply last time?
I don't have an exact time frame in my head on that.
What's your
right now.
estimate?
I would say it was about 2 or 3 months.
Okay. Is there anyone from the public who wants to be heard on this case? I don't see anybody for the record. Okay. What are you gonna have to do to bring the property into compliance, Mr. Sutton? I mean, you've got an RV.
Just get rid of all my stuff, or move it, and, it's a financial thing right now, I can't store it.
There's
I'm
a
not
truck,
throwing away a $13,000 motorcycle,
All right, I mean, it sounds, but you understand, and it keeps happening, so
Oh, yeah, I know what's happening, but I'm lucky I'm standing here. So really, it's, really don't matter a whole lot to me at this point. I gotta do something with this thing. I don't know what to do. Obviously, my dream fell through.
What's the county's recommendation?
The Citrus County Code Compliance Division respectfully requests that the special master assess a fine of $150 a day along with the administrative costs to begin after the date you deem sufficient for this violation, as well as granting access to the property for inspection. This amount was selected based on the action of the property owner once they were advised of the violation. We also asked the special master additionally to find it is responsibility to contact Code Compliance Division when the violation has been abated in order to allow for reinspection.
Based on what I can see, I would normally grant 30 days, but based on your testimony, I'll grant 60 days to bring the property into compliance. And if it's not brought into compliance at the end of those 60 days.
Well, how long does it take to get $42,000 worth of liens against it?
I have no idea. I don't know
That's
what the
was
amount
on
of
it
liens
when I
are.
bought it. That's what I had on when I bought it.
Right. And so,
And then
yeah,
I cleaned it up.
oftentimes.
I cleaned a lot up.
Oftentimes you can
I did a
ask
lot of
for
cleaning.
lien forgiveness, but.
There was junk everywhere.
At the end of the 60 days, if it's not brought into compliance, there will be a daily fine, probably similar to what happened before, at $150 a day.
Oh, yeah.
So you've got 2 months.
2 months to get it out of there.
To get it out of there. All right.
All they do is put the fines and put more liens back on that I got taken off.
Well, there won't be one if you bring the property into compliance.
Okay.
All right, good luck.
Next case on today's agenda, Casey and Kathy Anderson Moore, case number 2024-158. Code Officer Cody McGuire, page 25 of your agenda.
Do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
I do.
He's already been sworn in. Please state your name.
I don't remember him being sworn in. He should do it again. Casey Moore.
Thank you, sir.
Heather Moore.
Good morning.
How's it going?
Good so far. How are you?
All right.
All right. Please proceed.
Cody McGuire, Citrus County Code Compliance Officer, case number 202400158. Special requirements for all accessory structures, violation of Citrus County Land Development Code 3102A. Address is 11609 West Dragon Head Road, Chris River, Florida. Property owner is Casey and Kathy Anderson Moore. Good service via posting the property and posting at the Canto Government Building. I would like to authenticate the following documents and request they be admitted in evidence. Exhibit A, photos taken during initial inspection on January 31st, 2024. Photos taken during a corrective action inspection on July 18th, 2024. And photos of my final inspection on August 20th, 2024. Exhibit B is a copy of the notice of violation, copy of the notice of hearing, copy of the notice of hearing posted on the property, and the posting affidavit, and a pre-hearing order.
Okay. Sir and ma'am, I'd like to ask you to take a look at these documents and let me know if you have any objection to them being evidence.
What the heck is that? That's not mine.
That's not ours.
Well, Mr. McGuire, you'll have to direct your comments to me. If you think there's a reason to object to these, let me know.
Oh, okay. Well, this first photo's
Yeah, we
nothing
don't
to
know
do with
where
us.
that's at.
Okay.
That is,
Yeah,
yes.
that one's fine.
Is that from a different view?
That is not the same picture, but yeah. Maybe, I don't know.
That is from their house.
Yeah. Oh, I'm sure it's from their house. Those aren't my vehicles.
Yeah.
All right. So do you have any
I think
legal
we have
objection
that.
to these documents
No.
being
Oh.
evidence? What I'm hearing is that you may want to comment about the relevance of
That-
some of the
That
photos.
first picture, we don't know what that is.
Okay.
Just a picture of random woods, which
Yeah, I don't know what that
it could
is.
be anybody's
We'll
woods.
hear from Mr. McGuire, but are you contesting whether there's a violation on the property?
Oh, no,
No.
we know there is.
Okay.
We
Yeah,
just want
yeah.
to know what you guys want us to do, because
Okay.
we
Yeah.
thought we were doing everything, but then now we got sent here, so
Okay.
if it needs removed, we'll remove it. We don't know what you guys want.
Then we'll go through it.
Yeah.
All right.
Yeah, we thought it was like a stop work until the permits went through.
So, Mr.
we haven't
McGuire.
touched it since that day.
Okay. Mr. McGuire, they're saying that they don't understand the relevance of the first page. Can you, no, if you don't mind, can you see it from there?
Yes, sir.
Okay. Can you testify as to what this is a picture of?
Well, that black piece is a gate, and just above that, to the left a little bit, would be the roof of the structure.
Okay. So you're testifying that it is a picture of some portion of their
Correct.
property?
Okay.
All right. So I'm going to admit Exhibits A and B without objection. I do want to know, before we go further, is there anyone from the public who wants to be heard on this case? Okay. So, Mr. McGuire, they have said they're not contesting that there's a violation, but they may not understand what the violation is that remains or what they need to do to fix it. So I'm just going to let you present your case as you normally would, if you don't mind.
Not at all. On January 31st, 2024, I conducted an initial inspection and observed a structure on vacant property. On July 18th, 2024, a corrective action inspection was conducted with no change. I've had no contact with the property owner. As of my final inspection on August 20th, 2024, the property remains in violation and no permit has been issued for the structure on the vacant property.
So there's a structure that needs to be removed, is what you're saying?
I would now hand this over to
Okay.
Land Development Director.
Okay.
Joanna can see.
Sure.
So much taller. There's a residential lot, CLR, Coastal Lakes Residential. It's about 1.16 acres. They did apply for a building permit on February 27th of this year. That's after his first inspection. And it was denied on March 4th of 2024. Building had a long list of items. The health department needed a septic permit. Engineering also had some problems. There's been no activity since March 4th on the permit.
Okay, so from the county's perspective, they've explained in the rejection what needs to be done.
Correct.
And that's to bring it, so are they trying to permit the actual structure that's there, or?
I don't know. They're trying to do a house. So
Okay, all right. Does this make sense?
Kinda.
So,
Okay.
Originally, my mom's planning on building a house there, right? So my mom wanted to build like a shed for the kids to put like a pool table in, so that's what we did.
and we live one lot down.
I live right next door.
Yeah.
So I don't think he ever went to the property, but Mr. Gardner, the other guy that was in here, I seen him over there, so I stopped talking to him. He said, hey man, someone complained, it's too big to be a shed, you need a permit. So I got permits. Then they said they needed to change it to be a single-family dwelling, which that's not what we really
So you're
wanted.
saying you got permits for the shed?
Yes. But then they said you can't have just a single structure without a house. So
Yeah,
we
it
had to
was-
change all the blueprints through our engineer to be a single-family dwelling, which we did. And I'm waiting on Citrus County Health Department to come back with the perk test and the septic stuff. I already paid for all that, so.
Yeah, it wasn't
I can't
ever
do
supposed to
nothing
be
else.
a home, it was supposed to be somewhere where the kids could play until the house is built, because they can walk from our property to that property.
Okay.
So it wasn't supposed to be anything.
I now understand. So the
Yeah.
issue with this is that, I guess as you know,
I know now.
on these
Yeah.
residential lots, you can't have and that's an accessory use
Right. Yeah.
until the principal use is established.
So that's why, since the first violation, we haven't touched it. The kids
I
go over
know,
there
but
still,
that
we
means that
haven't
the
touched it.
violation remains.
That's why we want to know what you want us to do with it.
Well, you've got to do one of two things. Either you've got to go through the building process, address everything, and actually, I think, establish, it's not at the time that a permit's issued, it's when the principal use is established. Okay.
So if we get her, like my mom, to go forward on the house being built there, then we
Right.
should be good to go.
Once it's built, you're good to go.
Once it's built.
Yes. Until then, the only other way to remedy this is to remove the offending accessory
Okay.
use. Does that make sense?
Right.
So remove
That's
it, and then we're good.
Correct.
Okay.
I mean, that's my understanding. Okay.
Can we have like 60 days, because it's a lot?
A lot to remove that shed?
Yeah.
I can't, let me look at the picture.
It's like 20, well, it's
Oh,
like
okay,
20
that's
by
not,
16.
that's not a,
And it floods
that's
over
not
there.
what I was imagining.
Yeah, it floods over there, so
okay.
I built it on stilts.
It's not,
Yeah.
yes, what's the county's recommendation?
Citrus County Code Compliance Division respectfully requests that the special master assesses a fine of $150 a day along with administrative costs to begin after the date you deem sufficient to abate this violation. This amount was selected based on the actions of the property owners once they were advised of the violation. We would also ask that the special master additionally find that it's respondent's responsibility to contact the Code Compliance Division when a violation has been abated in order to allow for reinspection.
Yes, I think 60 days is reasonable. I'll grant that amount of time. If it's not done in the 60 days, it is going to be the $150 a day fine.
And
Okay?
who do we get a hold of once it's done?
Well, probably Mr.
You
McGuire, but I
contact
don't
our
know.
office.
Yeah, county code enforcement, code compliance.
Which is the number on top of this paper?
I would take it
assuming?
up. I don't know myself,
Correct.
but
So I reach out to you or Mr. Gardner, or any one of y'all?
Reach
The
out to
number on
code.
The
Okay.
number
All right.
here? Okay.
thank you.
That's all we
Thank
needed
you.
to know.
Yep.
Sweet.
Next case on today's agenda, Robert B. and Serena Greatrex, case number 2024-01161, Code Officer Cody McGuire, page 10 of your agenda, expert on the case, Joanna Katu.
Which page was this?
Page 10.
10.
Do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, ma'am.
Thank you. Please state your name.
Robert Greatrex. My wife is not here. She's at work.
Okay, good morning.
Good morning.
Cody McGuire, Citrus County Code Compliance Officer, case number 2024-1161, a violation of Citrus County Land Development Code Section 4002, site development without a development order or permit. Address is 1157 North Cross Point, Lecanto. Property owners Robert B. and Serena Greatrex. Good service via signed certified mail return receipt and posting at the Lecanto Government Building. I would like to authenticate the following documents and request they be admitted into evidence. Exhibit A, photos I took during my initial inspection on June 26, 2024. Aerial photos taken from the property appraiser's website. A corrective action on July 24th, 2024. And a pre-hearing inspection on August 20th, 2024. And Exhibit B is a copy of the notice of violation, copy of the notice of hearing, copy of the signed certified mail return receipt, and a pre-hearing order.
Okay. Sir, I'd like to ask you to take a look at these documents and let me know if you have objections to them being evidence.
The only objection I have is, I got served, the letter on the 8th, I'm sorry, on 8/1, so I
Mhm.
didn't get served, what would you say it was?
What? No. It's all right. So your objection is that you were served on August 1st.
Yes.
Okay.
Yeah, I got served paper, and then I come down here.
Yeah.
And I guess I needed a permit, so I come down here to buy a permit, and they said that there was no permit to buy to clear property.
Okay,
So
well,
guess, yeah.
I understand where you're coming from. I just want to make
Yeah,
sure
this
I
is
hear
good
the.
evidence.
Yeah, exactly. I don't know what the county's presenting yet, so
Okay.
I'm gonna admit these as exhibits A and B, and I want to know if there's anyone from the public who wants to be heard, just so I know. Okay, I don't see any response. And how do I pronounce your last name?
Greatrex.
Greatrex.
Greatrex, yes, sir.
Thank you. All right, please proceed.
Okay. I conducted my initial inspection on June 26, 2024, and observed that the property had but a few trees left. While researching the property, I observed that there was no permits applied for or issued. The aerial photos from the property appraiser summary depicts a large amount of tree cover of the property before the trees were removed. My coworker has had contact with the property owner on August 2nd, 2024, in which they went over the violation and was advised to speak with permitting. And as of my final inspection on August 20th, 2024, no permit has been applied for.
Okay. Now, I think you were beginning to testify that you were looking for a permit and they told you had no permit.
Yeah, I've got some evidence too to
Okay.
submit to everybody.
Okay.
This is just this is the site plan that I drew up.
Okay.
This is what it looks like now.
Okay.
I'm guessing you probably got pictures also. And I'm not here to contest anything. I'll say it on the speaker here.
Yeah,
I'm not here to
please.
contest anything.
Please.
My goal to clear the property was for agricultural purposes. My daughter has 2 horses. They eat a lot. I've owned that property for 8 years. I had the deed of the property to prove
How big is the
ownership.
property?
It's 4.82, I believe, is what it is.
Can you have horses on a 4.82?
I think you can
acre?
have 2 per acre.
Wow.
I believe.
Wow.
But I've got 2, and that's all I want.
So on a 5-acre property, you could have, okay, that's not, all right.
Is that correct? How much is it? if
I
you
mean,
know?
it's
Yeah, I
not,
don't know.
it's not relevant really,
Okay,
but
yeah, yeah.
I was just curious. yeah.
Okay. Yeah, I thought it was 2 per acre, which I only
That doesn't
want
seem
2.
like enough for,
It
but
doesn't, I can tell you
don't
it's
know.
not, because they eat a lot. So my goal was, again, for agricultural purposes, I was gonna clear this property. Again,
Mhm.
I've owned it for 8 years. I pay like $600 a year in taxes on it. So I thought, well, let me save a little money on some feed, and I'm gonna put some grass seed out here. So the diagram I presented for evidence, I'm guessing you probably got a picture of it now. That's the way I cleared it, and I went in there and left the big, huge, nice, beautiful oak trees. I left a border around the property. And again, I went on the website to attempt to find out if I needed a permit for agricultural use or whatever it might be. I think we're in dense residential out there. Everybody's got like 10 or 15 acres. So I don't want to say it's a mini farm area. I'm sure everybody knows if it is or not. It seems like it because everybody's got chickens and cows. So that was my thought, is to go in there and put some grass seed out there. I'd still intend to do so unless I can't. I was also going to remove the old fence that's up there, put some new fence up. That circle-looking thing over there is a round pen where my daughter's got a 3.5-year-old horse.
Actually, let's talk about that. So does the county have an objection to that being admitted? Because I haven't seen it yet.
I got an extra copy if you want one. I didn't know if I could approach the bench or not.
We have no objection for whatever weight the court.
Okay.
You want to see
All
it?
right, yes. Thank you. This is a copy of what you've handed to the others? Okay.
Yes, sir. That's just, like I said, a little site plan that I drew.
Okay, it looks nice.
And again, I don't plan
I'll
on,
admit it as respondent C.
if I can also add, sir, I'm not planning on putting 3 or 4 trailers on it and trying to sneak them in there and hook them up to rent them. I'm just trying to put some grass on there
Well,
for
my
this
job
horse.
here is not to ratify or deny your potential use of this.
Just the
or to
violation.
criticize or to say that it's beautiful, although I think it's a great idea.
Sure.
The issue before me is whether you basically changed your property in a way that should have gone through the county first.
Gotcha.
The answer to that is yes. So, I mean, are you aware of that? I mean, you've observed some of the hearings here today, but does that make sense as to why and how this code section applies?
The only thing that doesn't make sense is I don't plan on putting a structure on it.
Yeah.
I was just clearing it for agriculture. it kind of sounds a little odd to me that you can't do what you want with your property, but I know there's, you know, again, I know people sneak stuff on properties and try and hook it up and rent it, and that's not my intention.
Well, the reason why it sounds like that is because that is exactly the truth.
Right,
And the reason is that these are all the rules of things that you can and can't do with your property. Right. And, you know, if you want to change it, you've got to lobby your county commissioners to amend the code.
Yeah, I'm not lobbying anybody. I just, whatever y'all want to do, I'm here to fix it.
Okay.
I mean, I'm
all
not
right.
trying to contest
What's the county
anything.
requesting on this?
Just a one-time fine of $2,500.
I did would like to submit some more evidence.
Yeah.
I took and I wrote an apology letter to you. I wrote one to the officer.
This
and I
conceivably would be relevant for mitigating damages. This
Okay,
is
I was
fascinating.
basically what I was trying to do.
Well, let's see if it's admissible.
Yeah, I just I thought maybe
It's never happened before, I'll tell you that.
No, we don't
I was trying to get some leniency on the fine code.
I'd like to know what the county's position is on this.
Yeah, I mean, it's expensive out there. You know, these horses cost a lot to feed them, and I know these.
Yeah, they
fines,
do. Yeah, they do.
But I do understand the permit process.
Where are your horses now? You've got them?
Yeah, I have them on another piece of property. But I do understand the seriousness of the matter. I understand the code, the needs for code compliance.
Okay.
Putting structures on property when a hurricane rolls through. I know my stuff's not supposed, but all I'm putting up is some fence.
What's the county's position on the admissibility?
For whatever weight you want to.
I think it's highly relevant for mitigating damages. I admit it as Respondent's Exhibit D, and I'm going to read it. August 20th, 2024, to Office of Citrus County Code Enforcement, from Robert Greatrex?
Yes,
Greatrex.
sir. Yes, sir.
To whom it may concern, please accept this letter of apology for my actions in violating the Citrus County Code at 1157 North Crouse Point. I have been a county resident since 1979, and I do respect the need for all of the county's permitting and codes in place to keep Citrus County a safe community. My intentions were not to purposefully violate the code laws, and I know there is no excuse for ignorance of any laws. Thank you for today's hearing and understanding. I would fully comply with whatever needs to fix this violation. I'd say that's good for about $1,000.
That'd be great.
All right, so I'm going to find that there is a violation, assess a fine of $1,500, and that's it.
Okay.
Okay?
Now, would you like me to pay that, or are you gonna send me a bill in the mail or something?
You'll
Here?
get something in the mail.
Okay. Okay,
Next.
so am I okay to put my grass seed down?
That's an issue that you need to take up with the county.
Okay.
It's not for me to determine, and I encourage you to talk to them.
Okay. Do you have a
All right.
card that I can call you on?
Next
Good
case
luck.
on today's agenda. Jessica Lynn Cratz, case number 2024-494. Code Officer Julie Wilkinson, page 19 of your agenda.
The county's going to have to start increasing its proposed fines by $1,000 when everyone comes in with the.
Do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, ma'am.
Please state your name.
Jessica Cratz. It's
Thank you.
actually Living Good now.
Okay, well, good morning.
Morning.
You're on. Ms. Katu, I'm curious if you know, what is the horse rule here?
Varies by zoning. Some zonings, it's 1 acre in a house, some it's 2 acres in a house.
Wow.
In that particular zoning, it was no acres and no house, you can't have it.
Wow, okay,
Yeah.
thanks, jeez.
There's that option for conditional use, but he's
That's
not giving me the
fascinating.
acreage yet.
Okay, well. All right, Ms. Wilkinson?
Yes, sir. Julie Wilkinson, Citrus County Code Compliance Officer. This is case number 2400494, accumulation of junk and debris, a violation of Chapter 20, Article 3, Section 20-31A of the Citrus County Code of Ordinances. The address is 7091 West Sasser Street in Homosassa. The property owner is Jessica Lynn Cratz. I have good service via posting the notice of hearing at the property and at the Lecanto Government Building. I would like to authenticate the following documents and request they be admitted into evidence. Exhibit A, photos taken during initial inspection on March 15th, 2024. A corrective action inspection on June 28th, 2024. And photos for my final inspection conducted on August 20th, 2024. Exhibit B, a copy of the notice of violation, a copy of the notice of hearing, a copy of the general pre-hearing order, a photo of the notice of violation posted at the property, and a copy of the posting affidavit.
All right, ma'am, I'd like to ask you to take a look at these documents and let me know if you have objections to them being evidence.
God, it looks terrible. No, I don't.
Okay, are you contesting whether there's a violation on the property?
No.
Okay. How
I
long
mean,
do you
there
need?
isn't now.
I'm sorry?
I said there isn't now.
Oh, there isn't now?
No. I took a Bobcat in yesterday and we loaded a whole dump trailer.
Okay,
So none of that's there anymore. It's all dirt.
gotcha.
And we're getting ready to flatten that.
Is there anyone from the public who wants to be heard on this case, just so I know? All right, I don't see any response. All right, then without objection, what's been proposed as Exhibits A and B as evidence? And you went and inspected yesterday?
Yes, sir.
And was there still a violation yesterday when you were there?
Yes, sir.
Okay, all right, then please proceed.
On March 15th, 2024, an initial inspection was conducted and I observed loose trash, discarded furniture, bike parts, sheets of glass, miscellaneous junk and debris on the property. On March 15th, 2024, a notice of violation was issued for accumulation of junk and debris, which is a violation of the Citrus County Code of Ordinances. On April 1st, 2024, I conducted a follow-up inspection and found a lot of progress had been made in cleaning up the property, so additional time was given to come into compliance. On May 29th, 2024, I conducted an inspection and found more progress had been made, and I spoke with the occupant who walked me around the property to show him what needed to be done. More time was also given to finish cleaning up the property. On June 28th, 2024, I conducted a corrective action inspection and observed the property remained in violation and no more progress had been made towards cleaning up the property. As of my final inspection on August 20th, 2024, the property remains in violation. I have not had any contact with the property owner.
Okay, so this is the first time?
Yes.
I mean, it appears to me that based on a inspection done yesterday, there may still be a violation. I understand what your testimony is.
They didn't show up until late. They were supposed to be there for
I
3
got
days
you.
in a row.
Well, then
Just saying.
Then if I granted 7 days that wouldn't be a problem then, because it's already done.
Yes.
All right. Then what's the county's recommendation?
The Citrus County Code Compliance Division respectfully requests that the special master assess a fine of $100 per day, along with the administrative costs to begin after the date you deem sufficient to abate this violation. This amount was selected based on the actions of the property owner once they were advised of the violation. We'd also ask the special master additionally to find that it is the respondent's responsibility to contact Code Compliance Division when the violation has been abated in order to allow for reinspection.
Yeah, and I mean, it didn't look that bad as of yesterday. Like, it looked doable anyways, so I believe it can be done.
It was.
All right, I'll give 7 days. It'll $100 a day if it's not done in 7 days, and good luck.
Okay.
All right.
Thank you.
Thank you.
Next case on today's agenda, Deanna Jerry Williamson, case number 2024-1037, Code Officer Julie Wilkinson, page 31 of your agenda, expert on the case, Technical Services, Stormwater Division, Tiffany Crosby.
Tiffany? Do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God? I do. Thank you.
Julie Wilkinson, Citrus County Code Compliance Officer, case number 2401037. A violation of Citrus County Land Development Code, section 4100, site improvement plans. The address is 11667 West Clayton Drive, Homosassa, Florida. Property owners,
11664.
Oh, I apologize. 116, the address is 11664 West Clayton Drive, Homosassa, Florida. The property owner is Deanna Jerry Williamson. I have good service via posting the notice of hearing at the property and at the Lecanto Government Building. I would like to authenticate the following documents and request they be admitted into evidence. Exhibit A, photos I took during my initial inspection on May 3rd, 2024, and photos for my corrective action inspection on June 20th, 2024, and photos for my final inspection on August 20th, 2024. A copy of the notice violation, a copy of the notice of hearing, a copy of the general pre-hearing order, photo of the notice of violation posted at the property, and a copy of the posting affidavit.
Is there anyone from the public who's going to want to be heard on this case? All right, then without objection, Exhibits A and B are evidence in this case. Please proceed.
I conducted my initial inspection on March 3rd, 2024, and observed the property had been modified. There was fill that had been brought in. While researching the property, I observed that there was no site improvement plan that had been applied for or issued. I have had contact with the property owner who stated that she had brought in 4 loads of fill into the back of her property and 2 loads of fill into the front of her property and rock for her driveway. A notice of violation was issued on June 3rd, 2024 for site improvement plans. On June 20th, 2024, I conducted a corrective action inspection and found the fill dirt remained on the property with no site improvement plan that has been applied for or issued. As of my final inspection on August 20, 2024, the property remained in violation. No site improvement plan has been submitted. Expert on the case is Tiffany Crosby and Joanna Couture.
Okay, welcome.
Hi, Tiffany Crosby. We're requesting that they submit a site improvement plan that would show the pre and post grading so we can better address the modifications that took place.
So you're requesting a site improvement plan pursuant to LDC 4100, and the reason is for what?
For the fill that was brought in.
Well, you had mentioned something about grade. I'm not sure. I just couldn't.
So when you bring in the fill, you've altered the grading patterns of that lot, so we would need to see what the proposed grading would be.
And that would be shown on the site improvement plan.
Yes, sir.
Now, if it is shown, I mean, does the violation go away?
If the permit's issued, then it would go away. We just need to be able to see what the proposed, to make sure it's not impacting any of the waterways, any surrounding areas.
And is that why you brought it under 4100 and not 4002 or whatever the other section is?
It was brought under 4100 because there is a residence on this property, so it's not a vacant lot.
I see.
Yes.
Okay. What is the county what is the county requesting from me?
A one-time fine of $2,500. Yeah.
So just to add to that, on the site improvement plan, one of the key things we check for existing and proposed grading is any potential impacts, which what we deem as an illicit discharge or connection. It's a separate ordinance that deals with that, but if we don't see those corrections in place, then it does become, in this case, would be an illicit discharge.
Okay.
Because it's on the waterfront
That
area.
makes sense.
She's our stormwater expert.
Okay, well, it makes sense. And, you know, we don't joke about water. So I'm just trying to, I don't often see this code section, so I'm trying to, and I think it's changed since the last time I saw it, but I want to take a look at it here. Okay. All right, I'll go ahead and assess the fine of $2,500. That's my order.
Thank you.
Next 2 cases on the day's agenda. Leah Lynch, case number 2024-788 and 2024-789. Code Officer Cody McGuire, pages 22 and 23 of your agenda.
Good morning.
Good morning.
Do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, ma'am.
Thank you, ma'am.
You're
Please-
welcome.
Please state your name.
Leah Lynch.
Thank you.
All right.
Cody McGuire, Citrus County Code Compliance Officer, case numbers 202400789 and 788.
Yep.
You want to run them together or separate?
I would like to run them together.
Okay. The 789 is
And ma'am, does
unlicensed.
that make sense? We're going to hear both cases
Yeah, that's
instead
fine.
of, okay.
789 is unlicensed inoperable vehicles, is a violation of Chapter 20, Article 6, Section 20-31 of the Citrus County Ordinances, and 788 is accumulation of junk and debris, a violation of Chapter 20, Article 3, Section 20-31A of the Citrus County Code of Ordinances. The address is 9684 West Sandra Street in Christian River. Property owner is Leah Lynch. Good service via signed certified mail return receipt and posting at the Lecanto Government Building. And then I would like to authenticate the following documents and request they be admitted into evidence. And these are the same dates. Photos taken during initial inspection on April 22nd, 2024. Corrective action inspection on July 18th, 2024. And photos of my final inspection on August 20th, 2024. And Exhibit B is a copy of the notice of violation, copy of the notice of hearing, the signed certified mail return receipt, and a pre-hearing order.
Okay. Now, ma'am, I'd like to ask you to take a look at these documents and let me know if you object to them as evidence in this hearing.
Okay.
Okay?
This one's what, yesterday? No, this was the original. Oh, okay. I forgot that truck's not there. All right, so this is the beginning. Okay, which all of it's gone but that. And then, okay. This is the beginning also. And this is, okay, this is when you came. It says 4:30 though. And this one says 4, okay, so this is when we started cleaning up everything. Okay, okay. And then this is, okay, recently. Okay.
They're going to look the same almost.
Okay, what is this one for?
That one's for
Oh,
the
one's
junkyard.
for the junk food, which that's that stuff. Okay, and that's
While
all
they're
good.
doing that, is there anyone from the public who wants to be heard on this case? Okay. I don't
This
see
is
any
the newer one.
response.
Oh, no, that's the 30th.
Still going from the beginning.
Okay.
That was as of yesterday. All right, then, did you have any objection, ma'am?
No, it's my son's house.
Okay.
I gave it to him and my daughter-in-law. They had a baby on the way. The reason why the progress had stopped in July till, well, he's seen that we did more. They ended up having my grandson the 27th, the day after I got served. And there was some serious complications with the delivery.
Thank you.
Everybody's good now. We're doing everything. The biggest thing we're waiting on, and it's with all of our misunderstanding, is the vehicle that's there right now, the truck
Yep.
that's covered.
Yep.
It is actually registered and insured.
Okay.
But it was wrecked, and we're trying to get somebody to come and just scrap it.
In other words, it's not usable.
It's not usable.
Yeah.
No, he rolled it 6 times in December. We are trying, like we've been trying. We've got messages out to numerous people. I've reached out to customers at my job because I don't physically live at that address. Like I said, I live in another house I bought. That's my son's house. But we are making progress, and but if I could just get a little bit of time, so I
Yeah.
could try to get that Beamer and that truck body
So
picked up.
how many vehicle, let me
It's-
ask you, so how many vehicles are at issue in this case?
From the beginning or?
No, right
the-
now.
There is the black BMW and the truck that's covered under the tarp right now.
Okay, so two,
Mhm.
and she's talked about those, okay.
Mhm.
On the, let me look through the photos on the junk, I mean, essentially, I don't hear you contesting that there's a violation,
No, I just
right?
need some time
It does
more,
look like there's been some improvement, let's see.
No, there's been a lot of improvement.
Okay.
You were out there
Honestly, it's a little
yesterday?
difficult to tell
Yeah.
because it doesn't look too good today. You know, like I see the weight equipment, I see well, no, it does look better. You're right. You're
Yeah,
right.
there's been a lot of dump runs. I work,
how
you know, my husband works, my
How
son
much
works.
How much time do you need to bring it?
Could I
in?
get like at least 3 months? I mean, it will be done beforehand, but just, you know, it's, my biggest issue is getting somebody to come pick up that
Right.
truck, because it has to be loaded on a flatbed. And I've got a couple people my husband's reached out to that we're still waiting. We had to send them a VIN number for the cars and proof that we had the titles, because the truck is still registered and insured. Like I said, I didn't know anything else like that. I made my son keep it on, you know, legal.
First of all, exhibits A and B are admitted in each case. Here's what I'm gonna do. I'll give you 90 days on the vehicles.
Okay.
I'll wanna hear what the county has to say about the proposed fine, but, on the cleanup, I've gotta give 30 days. I think it can be done in 30 days. I don't know. I don't see any huge issues, but for your neighbor's sake, I think 30 days is reasonable. Not your neighbors, your son's neighbors. What's the county's recommendation on the fines?
For both cases is $75 a day.
Okay, so, on case number 2024-789, I will grant the request for 90 days. It's $75 a day if it's not done. And then on 2024-788, it's 30 days and $75. Okay, good luck.
Thank you.
Thank you.
Next case today, Donald Haider and Antoinette Wasserman, case number 2024-423, Code Officer Julie Wilkinson, page 14 of your agenda. Expert on the case, Land Development Director Joanna Coutu.
Do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Please state your names.
My name is Donald Haider.
Antoinette Wasserman?
Thank you.
Okay, good morning.
Melissa.
Julie Wilkinson, Citrus County Code Compliance Officer, case number 2400423, special requirements for all accessory uses, a violation of Citrus County Land Development Code 3102A. The address is 7595 West Narcissus Lane in Homosassa, and the property owner is Donald Haider and Antoinette Wasserman. I have a good service via signed certified mail return receipt. I would like to authenticate the following documents and request they be admitted into evidence. Exhibit A, photos taken during initial inspection on March 11th, 2024. Photos taken during a corrective action inspection on July 2nd, 2024. And photos for my final inspection conducted on August 20th, 2024. Exhibit B, a copy of the notice of violation, a copy of the notice of hearing, a copy of the general pre-hearing order, and a copy of the signed certified mail return receipt.
That's in the container, was still there.
Sorry, I should have been more clear. I didn't say anything.
No.
Let me know if you have any objections to
Oh,
these.
no objection.
Okay, all right.
Did she, okay.
Is there anyone from the public who wants to be heard on this case? Mr. Fabricius, nothing?
What was the question again?
Do you want to be heard on this case?
Am I a party to it?
No, I was curious. You've been patient. You've been sitting here.
I just want to make sure that for everything
Mhm.
There's no fines against me and my landlord? Because I'm understanding that
I'll take that up. I will take that up after this case. I will talk to you about that, okay? Okay. All right, so no objections to this. Exhibits A and B are evidence. I don't hear anyone else from the public. Let me ask you this. Do you understand the case that's being brought against you?
Yes.
Okay. Do you contest whether there's a violation?
You contest the violation?
Are you contesting it?
Yes.
Okay, all right, so proceed.
On March 11th, 2024, conducted an initial inspection, observed an RV, a shipping container, a carport, and a garden materials on the vacant property. I spoke with the property owner, Mr. Haider, and advised him of the violation. He stated that the RV is a park model and will see about getting it assessed as a mobile home. I gave him a verbal warning at that time. The context container was observed to be removed from the property in April, but everything else remained. I conducted a follow-up inspection on May 1st, 2024, and found that the property remained in violation and the RV had not been approved as a mobile home. So on May 3rd, 2024, a notice of violation was issued for special requirements for accessory uses, which is a violation of the Land Development Code. On July 2nd, 2024, I conducted a corrective action inspection and found that the property remained in violation. As of my final inspection on August 20th, 2024, the property remains in violation. My expert on the case is Land Development Director Joanna Katu.
Okay.
Medium density residential with mobile homes allowed. It's residential, 0.15. There's actually two very small acre, 0.15 acre and 0.15 acre next to each other.
Okay.
There was a mobile in 2020 that was demolished. We don't have any permits since that time for any kind of permitted use.
Are you aware of whether or not it's possible to permit this?
Yeah, I thought about that when she said that. Theoretically, it might be through engineering and permitting. I don't know how, I think that would be very extensive, but I think theoretically it could be possible.
No, I'm just curious, when y'all talk about engineering, what's the engineering aspect of this?
That is wind loads to meet the Florida Building Code, and that's the problem is when you talk, an RV has this container, and once you cut into it or design it, you've changed the wind loads. I'm very, very layperson here, but that's my understanding is once you change that RV in any way, even putting them together, you're impacting the wind loads, so an engineer has to come in and recertify and figure it out.
Okay, that makes sense. Ms. Wilkinson, is the carport a part of this?
Yes, sir.
Okay.
The only thing on this property that's allowed to remain is the shed, because during the demo permit, it specifically says that the shed is to remain.
So I see some like solar poles.
Everything.
Everything. Okay.
Everything, even the garden wall, the raised garden bed, and there's some fencing material, everything should be
Unless
removed.
somehow they're able to get it permitted and go through engineering and so on.
That's correct.
That's the county's case.
Yes, sir.
Okay, what's your defense?
Well, it's,
I mean, it makes sense to me. And have you tried to get this permitted? Are you trying to get the engineering?
We haven't really tried to get it permitted, but we went through the county and had it changed, converted, I guess is that the word, to a mobile home.
Mm-hmm.
Right?
And it might be able to be allowed to stay on the property, but we don't know. And without knowing and without it being properly permitted and going through the engineering to make sure that it satisfies, for example, the wind loads required under the Florida Building Code, that's to protect you, if there's a storm. It's a violation of the code.
Go ahead.
Okay. We have some exhibits here, but we went through the statute, the Florida statutes.
Okay.
And it says that you can make an RV into a mobile home.
Right.
And we went to DMV, and we went to the appraiser, and the appraiser came out, and they appraised it, and it's on the county record now as a single-wide mobile home.
Right.
With a retired title, and it's on the tax rolls.
You've retired it to the property.
Yeah, it was on the deed.
Okay.
Do you want to see this stuff?
You need to present to me, I am interested in seeing it, yes.
Give it to who?
So I think what they're referencing, there's a note on the property appraiser's records that says, at the request of the property owner, the RV is being labeled as a mobile home. I think labeled might not be the word, it might be considered as. There's a notation in their property notes on that. So it's the property appraiser that they're discussing.
I know, yep.
Okay.
Can I ask a few questions?
Yeah.
There's photographs here. Who took these?
We did.
And when did you take these?
Oh, I guess back in April, after we took the container off. There's actually a little over half an acre. It's .53 is the size of the property.
We have no objection to the photographs.
Okay.
She has a little exhibit list on the front as well to help the court. We have no objection to the property appraiser's records, which they have marked as exhibits B and C.
Okay.
The only objection to D, which is the deed, would be relevance. It
Okay.
doesn't address the mobile home or anything.
It has the mobile home on it.
Well, hold on a second. So what's the objection to Exhibit D?
All I see on here is a legal description and of the property, and then somebody hand wrote something on here.
What's the title of it?
Florida warranty deed to individual grantors. It's not a copy, it's not a certified copy from the clerk, and there's something handwritten on here.
Okay.
So I don't know if that's part of the official record or if something was handwritten
is.
after the fact.
All right,
since
then I'll
it's not a
reserve
certified
ruling and I'll
copy.
let you talk about it.
This is marked as Exhibit E. It's a statute regarding taxation that has nothing, no relevance to do with what we're dealing with here.
I'll
There's
reserve
nothing
and
for
get their
taxation.
response on it.
This appears to be an application to the property appraiser's website. Again, Exhibit F, relevance as to today. This is their registration, is Exhibit G, again, relevance. Exhibit H appears to be a cancellation of title. We would have an objection for relevance as well. And then this is their bill, Exhibit I is their bill from the property appraiser's website. Again, we'd have an objection to relevance on that.
Okay, so we'll go through all of them individually. All right, thank you. All right, so Exhibit A is the photos, correct? So Respondent's Exhibit A is stipulated, or no objection to it. I've got an index here of the exhibits, that's useful, thank you. Exhibit B is, there's no objection to that, I believe, correct?
Correct.
So that's admitted. These are gonna be Respondent's Exhibits A and B. And was there an objection to Exhibit C?
No, that's the other document from the property appraiser's website.
Okay, so no objection.
No objection.
Okay. All right, Exhibit D, Florida warranty deed, individual grantor, you object to this?
Yes.
Okay. What is the relevance of the warranty deed? And it appears to have the recording information.
That's how it's recorded in the
So
county.
It's a
That's
public
what-
record.
yeah.
But what is the relevance of it?
Let's see. It's, the RV is on there. It says, together with all tenements, blah, blah, blah. 2012 Hampton Crossroads ID number, blah, blah, blah. That's on the deed.
That's the ID
recorded in the
number,
county.
that's the ID number of the,
Yes.
okay,
Right.
okay.
I mean, when we bought it, it was on there, we bought it as a unit, we bought it, you know, as the
Just
way
the,
it is.
just the way, yeah, just the way it is now is
And it
how
had
it
been
was
there
when
for
we bought
years.
it, except the
I
container.
mean, it's a
was
public
on there.
record, I'll admit it.
And we
On, you appear to have attached a statute, Florida Statute 193.075. I would take judicial notice of it anyways, but what is the relevance of this?
That's, we looked that up and that's what we went by.
Okay, I understand. I don't think this law is going to be relevant for us. And the reason is that you're here because this is a code issue, like a county, a Citrus County code issue. It's not a tax. This talks about how something is taxed.
Okay.
It doesn't, so I'm taking judicial notice of it, but I don't find it relevant. All right, so this is Exhibit 5, Declaration of Mobile Home as Real Property.
From the appraiser's office.
From the appraiser, well.
That's who signs it.
I see. Okay, let me see. But what's the relevance of this? Is that you've declared that the mobile home is
Yeah,
real
yes,
property?
Yeah.
Okay. And it's your, so I'm assuming that your defense is that because the mobile home is taxed as real property, it's considered real property by the property appraiser, that it should be established as a principal use in Citrus County?
Yeah.
Okay. I'll admit it. I'll let you build your defense. I'll explain why I don't think that's the case, but that's Exhibit F, and that's admitted as evidence. Now, it jumps to H, and you have listed an Exhibit G, which is a decal.
Did I keep some? I don't think
I
kept
don't
anything.
know, maybe I've misplaced it, but do you know what I'm talking about,
Yeah.
the decal?
It's this page. It would look like that.
Maybe it's attached to, oh, I'm sorry, it's attached,
Okay.
all right, let me look at Exhibit G.
That's where the real property decal came from, which is displayed on the front
Oh, I
of
see,
it.
real property registration. All right, so again, I understand what your case is. I'm gonna admit that as evidence. That's a legitimate, I understand the defense. Transaction you have requested has been completed. The title for the above referenced mobile home has been retired. So this is a copy of a document from a couple months ago.
From DMV.
After this case started, that says the title has been retired. Okay.
Because it's on the deed.
Okay. I'll admit that. And then the property appraiser value information is evidence that it's now recognized, I guess, as a part of the real property. You're being taxed.
Mhm.
Yeah.
Is that the purpose of the?
Yeah.
Okay. I'll admit it. Here's my issue with that is in order to have a principal use established, you have to go through permitting. So even you've satisfied, in my opinion, you've gone through some other steps to retire a mobile home on the property, that's fine. It's now taxed as real property, but that's a separate thing from whether or not it is now permitted under Citrus County Code as something you're allowed to live in that satisfies the Florida Building Code, where the engineering's been done, and that's what you have to do. So that's the issue. Nothing you've done here is wrong. I mean, but it doesn't address what the county has brought you here today for.
Okay, so what do we have to do to move forward?
There's two ways of moving forward, or there's two ways of fixing the violation. One is, as Ms. Wilkinson said, removing everything, essentially. The other way is to get the engineering done on what you've got and permit what you've got. And that's what you've got to do. It's one or the other. And if, based on your feedback, I can maybe work with you on giving you some time to do one or the other. The question is what you prefer to do.
Okay. When you say get the engineering, can you explain that a little bit?
I'm
more?
not an expert in that, but there's a permitting process that you'd have to go through to establish this as a principal use. And they're not promising that it can be. What you heard from Ms. Katu is that it's possible. Like, it's been done before. There are other, I mean, it's theoretically possible.
Okay.
But it would have to go through a process, and I don't know how long that process takes. And it's probably dependent on who you hire to help you as well. Do you know how long it takes, Ms. Katu, or do you know how long it's taken in the past?
The reason I said theoretical is correct. I don't recall this happening.
Oh, okay.
I know engineers are very backed up, but I don't know if they can get it converted to meet Florida Building Code or not.
So is that's going to be true in any residential zoning for this?
Correct. Any residential lot could not have the RV placed on it as the primary structure, the principal structure. So they could establish a principal structure and then perhaps.
So I'm sorry, that's a third way. You could
Yeah.
establish a principal structure. You could get a site built or a mobile home,
Sure.
another, like a mobile home.
Maybe easier and cheaper than the conversion, but I don't know.
So you have three options.
Maybe even what was the last? one?
Maybe easy, quicker and easier than having the other engineered.
And that's expensive?
Yeah.
So how much time would you need or to do one of these things?
So, go ahead.
Well, to do different times, I guess, for different things.
So who would we talk to about doing all that?
Yeah.
Joanne Katu? Is that who?
Yeah.
Who would we come to?
Definitely not. I'm not in building division. I think if you want to talk to building division, they're out there in our lobby and they can try to help you a little bit, but you're going to need to get with a private engineer and have them help you with that, or a private contractor that has an engineer on board as well that can help.
And more or less draw plans, is that what you're saying?
Yes,
Okay.
yes, for a permit. Sorry, we're doing back and forth, I know.
No, I
sorry.
appreciate it. I want that in this case. So I'm gonna find that there's a violation, and I'm gonna give a time before a fine begins. Now, you know, I can't give a huge amount of time. I can give you time, but I'll tell you that frankly, I think you're probably looking at, how much time do you want? How much time do you need?
I don't know, you said
I mean, it
it's all,
doesn't look.
they're backed up.
Well, we're heading into storm season. We are in storm season. So there are potential safety concerns.
It's been there for 4 years. I mean, we bought it, it was there. The people lived in it for 3 years.
I know. A lot of people lived in homes in
Okay.
Homestead
Yeah.
before Hurricane Andrew came.
Okay.
So how long do you think it would take to
go
do
through all
that?
of that?
Because, yeah, I mean, at some point down the road, I mean, my wife is going to be in that home.
I mean, that's the point. Eventually, I would move there.
I'll tell you what I'm going to do. I mean, I'm going to give 120 days. All right?
What's that, 4 months?
So I'm going to
Okay.
find a violation, grant 120 days to abate the violation. What's the county's recommendation?
$100 a day, along with the administrative costs to begin after the date you deem sufficient to abate this.
So that's all going to be incorporated. I mean, I'm giving you more time because I don't think it looks bad. You know, I don't think it's offensive from a code perspective, nuisance-wise.
It's probably one of the better looking
Well, that's
properties in that
that's what
neighborhood.
I'm saying.
Yeah.
But at the same time, the law is the law. So
Okay. All right.
if it's not brought in compliance as ordered, $100 a day.
Thank you.
Okay. Good luck.
All right, thanks, sir.
Did you want to address Mr. Fabricius? or-
I'm sorry. I do. Yeah. Let me ask you a question, Mr. Charlton. So
Yes, sir.
was he on the preliminary agenda?
Yes, sir.
Okay.
He was.
Okay.
No, he was not. I apologize.
Oh, he wasn't? Okay.
No, sir. His case closed. It
Okay.
abated prior to.
All right. Since he's here and he's a member of the public, I just want to take it up now. And would you like to come to the podium, or are you good there?
Go ahead. Go ahead.
Okay.
Would you like me to come?
Yeah, if you don't mind. Thank you for your patience. Yeah.
Mr. Fabricius, I need you to raise your hand. Do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
Absolutely.
Thank you.
I'd like you to be able to go home, so if we can give some answers. Is it the county's understanding that they're going to bring a code case? Are there any pending code cases?
No, sir.
Okay. Is the county seeking any fines from me against him
No, sir.
or on the property?
No, sir.
Does that answer your question?
It sounds like it's all cleared,
That's exactly right.
and I have nothing to be concerned about.
Well, I wouldn't say that. We live in a dangerous world. But from the code compliance perspective, there is not currently a pending case. There is nothing before me, and you will not, no one's going after you or your tenant for any fines.
All right, thank you.
Thank you. Thank you, Mr.
Thank
Charlton.
you.
So I'm done.
Yes, sir.
Next case on the day's agenda, Charlene Barons, case number 2024-1222, Code Officer J.C. Charlton, page 5 of your agenda.
Do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, I do.
Thank you. Please state your name.
Charlene Barons.
Thank you.
Ms. Barons, what I'll tell you is this. My last name starts with a W, and I was always the last in the lunch line in elementary school. I was always the last in my PE class. You know, I'm at the end of the alphabet. You're actually in the beginning. So even though you're the last today, you've had it good. So, all right?
I was usually at the beginning, but nobody could say my name, so.
Yeah, well, that's, I guess that is a trade-off. All right.
Yes. Good morning.
Good morning.
Received this case and the cases that I will be presenting this morning from Code Officer Amy Becker, who has retired.
What? She has?
Yes, ma'am.
Good for her.
Was that planned?
Good for her.
Was that planned?
Yes, ma'am.
Good
Yes,
You
for
sir.
knew
her.
that
Yes, sir.
she was retiring?
Yes,
Yeah, she
sir.
told me she was.
No one told me. I would have. All right. Wow. Okay. Well, good for her.
J.C. Charlton, Citrus County Code Compliance Officer. This is case number CE 2024-1222, unlicensed and inoperable vehicles, a violation of Chapter 20, Article 4, Section 20-41 of the Citrus County Code of Ordinances. The address is 7920 North Saracen Drive. Property owner Charlene Barons. Good service via signed certified mail return receipt. I would like to authenticate the following documents and request to be admitted into evidence. Exhibit A, photos taken during initial inspection on July 5th, corrective action inspection on July 12th, follow-up inspection on August 12th, and a final inspection conducted on August 19th, all of 2024. Exhibit B, notice of violations, notice of hearing, pre-order information, and signed certified mail return receipt.
Okay. So, ma'am, I'd like to ask you to take a look at these documents. Let me know if you have any objection to them.
The vehicle did turn around.
Yes, ma'am.
I'll explain that in a minute.
Okay.
No.
All right. Are you contesting whether there's a violation on the property?
Yes.
Okay. And is there anyone from the public who's going to want to be heard on this case? I don't see anybody. Okay. How long did Ms. Becker work here?
31 years.
Yeah, she's been here forever. She's been here since I've been in the county.
That's amazing. All right, thank you. Without objection, what's been proposed as Exhibits A and B are evidence.
An inspection was conducted on July 5th, 2024. Photos depict an inoperable white truck, missing front tires on a jack in the driveway. Corrective action inspection was conducted on July 12th. The inoperable truck remained on the property. I've had no contact with the owner until this morning at this hearing. As of my final inspection on August 19th of 2024, The inoperable vehicle remained on the property with the mid-jack up under the vehicle and the tarp sinking down in front because the hood is not on the vehicle also.
Ms. Barons, what's going on?
My grandson is an 18-year-old, and he builds his truck.
Mm-hmm.
On the first offense, his axle had literally broke a block from the house and had to be towed. And he was trying to get parts. He is a full-time student finishing up his high school, and he works full-time.
Mm-hmm.
So he got it back operable, and then he decided 2 weeks ago to pull the motor out of it and rebuild it.
Mm-hmm.
He's a motorhead.
Yeah. Okay.
The motor is in the garage, and the jack is for the, I don't know, the differential or whatever underneath there. Okay, and the tarp is there. The motor is in the garage. He is getting ready to redo it. He will have it back in. He promises me by this week, but that is licensed and insured, so I don't.
That is an inoperable vehicle.
Yes.
Okay.
It is. That's why I said it's,
Well, you. Okay.
It is, and then it wasn't, and then it is again.
How much time do you need to get this thing operable?
He promised me this weekend, but I don't want to do that because he does work full-time and he does go to school. So he should have his motor back in there. I don't know.
Well,
I'm not a motorhead, so, 30 days, 2 weeks.
Okay. What's the county's recommendation?
Citrus County Code Compliance Division respectfully requests a special master assess a fine of $50 per day along with the administrative costs to begin after the date you deem sufficient to abate this violation. This amount was selected based on the actions of the property owners once they were advised of the violation. This amount is appropriate given to the severity of the violation and respondents' actions relative to this violation. We'd also ask the special master additionally find the respondent's responsibility to contact the Code Compliance Division when the violation has abated to allow for reinspection.
Okay. I'm going to grant 14 days.
I'll tell him.
You said 7. I mean, listen, kids got to be held to their word. All
I know.
right?
He was in his room last night making gaskets, I guess that's what it's for.
Does the violation abate if it's put in a garage or something?
Yes, sir.
It does. So, I mean, if it's out of the public view and it's a closed garage.
He can't fit it in there with all of his other stuff.
Yeah. Well,
I'm just
then hard choices have to be made.
I know.
All right, 14 days, and if it's not brought in compliance in 14 days, $50 a day.
All right,
Thank you.
Thank you. Y'all have a blessed day.
You
If
too.
anybody says Amy,
Yeah.
tell her good luck.
I'll tell her.
Next case on the day's agenda, Johnny Geraldo Gonzalez, case number 2024-222, Code Officer Cody McGuire, page 9 of your agenda. Expert on the case, Joanna Coutu, Land Development Director.
Cody McGuire, Citrus County Code Compliance Officer, case number 202400222, violation of Citrus County Land Development Code Section 4002, site development without a development order or permit. Address is 8219 North Hatfield Terrace, Chris River, Florida. Property owner is Johnny J. Geraldo Gonzalez. Good service, posting the property and posting at the Lecanto Government Building. I'd like to authenticate the following documents and request they be admitted into evidence. Exhibit A, photos I took during my initial inspection on March 11th. Aerial photos taken from the property appraiser's website. Corrective action on July 18th and a pre-hearing inspection on August 20th, 2024. Exhibit B is the copy of the notice of violation, copy of the notice of hearing, copy of the posting affidavit, and a pre-hearing order.
All right, without objection, what's been proposed as exhibits A and B will be evidence. Is there anyone from the public who wishes to be heard on this case? All right. Please proceed.
Okay. I conducted my initial inspection on March 11th, 2024, and observed the property had all trees removed. While researching the property, I observed that there were no permits applied for or issued. In the aerial photo of the property appraiser's office, summary depicts a large amount of the tree cover from the property was removed. I had contact with the property owner March 28th, 2024, in which we went over the violation. As of my final inspection on August 20th, 2024, no permit has been applied for.
What did you say about the violation?
He said that he cleared the trees thinking that he was able to.
Yep. All right. Ms. Coutu, do you want to testify or? I don't think so. What's the county recommending?
A one-time fine of $2,500.
All right, the fine is ordered.
Next case on the day's agenda, Emmy Lavender, case number 2024-478, Code Officer Cody McGuire, page 21 of your agenda. Expert on the case, Joanna Coutu.
Cody McGuire, Citrus County Code Compliance Officer, case number 202400478, a violation of Citrus County Land Development Code, section 4002, site development without a development order or permit. Address is 11864 West Cornflower Drive, Chris River, Florida. Property owner is Emmy Lavender. Good service posting the property and posting the Canto Government Building. I'd like to authenticate the following documents and request they be admitted into evidence. Photos I took during my initial inspection on March 13th. Aerial photos from the property appraiser's website. Corrective action inspection on July 18th and a pre-hearing inspection on August 20th, 2024. Exhibit B is a copy of the notice of violation, copy of the notice of hearing, copy of the posting affidavit, and a pre-hearing order.
All right, without objection, the county's exhibits are evidence. Go ahead.
I conducted my initial inspection on March 13th, 2024, and observed the property had trees removed and groundwork completed. While researching the property, I observed that there were no permits applied for or issued, and aerials from the aerial photos from the property appraiser's office summary depicts a large amount of trees of tree cover on the property before the trees were removed. I've had no contact with the property owner, and as of my final inspection on August 20th, 2024, there has no permit has been applied for.
What's the county's
$2,500
seeking? All right, a fine of $2,500 is ordered.
Next case, Kathy Marcy, case number 2024-407, Code Officer Julie Wilkinson, page 24 of your agenda. Expert on the case, Joanna Coutu.
Did Ms. Becker leave any last code compliance wishes as she retired? Were there anything, Mr. Charlton?
She hopes Citrus County.
What were Ms. Becker's last code compliance wishes?
Oh, just to keep the standard, you know.
Okay, all right.
She did a lot of hard work in Beverly Hills, and I better not let her
Oh,
down.
okay,
Yes.
okay. So that's like, that was her focus. All right, interesting.
All right. Julie Wilkinson, Citrus County Code Compliance Officer, case number 2400407. Land Development Code 3102B, special requirements for all accessory uses. The address is 5591 South Shalimar Point, Homosassa. Property owner is Kathy Marcy. I have good service via posting the notice of hearing at the property and at the Lecanto Government Building. I would like to authenticate the following documents and request they be admitted into evidence. Exhibit A, photos taken during initial inspection on March 11th, 2024, photos from a corrective action inspection on April 30th, 2024, and photos from my final inspection conducted on August 20th, 2024. Exhibit B, a copy of the notice violation, a copy of the notice of hearing, a copy of the general pre-hearing order, a copy of the notice of hearing posted at the property, and a copy of the posting affidavit.
All right, without objection, the county's exhibits are admitted as evidence. I don't think I'm going to ask if are you aware of any members of the public who are still here?
No.
Okay, then I won't be asking for public input anymore. Go ahead.
On March 11th, 2024, I conducted initial inspection and observed that a shed on the property had a bedroom, living room, and kitchenette set up inside. The shed appeared to be lived in. On March 11th, 2024, a notice of violation was issued for special requirements for all accessory uses. On April 30th, 2024, I conducted a corrective action inspection and found that half of the shed had been converted back to storage use, and the other half had a living room set up and a taller bed set up. The shed did not appear to be lived in at that time, and the case abated. However, this complaint has come into the office 3 times. Each time, the complainant removes everything from the shed for inspection And after the case is closed, the shed is converted back into living quarters. For this reason, this case is being brought before the special magistrate. And you will notice in the one of the final photos that I took yesterday, she really wanted to show me that she's living inside the house now with her bed set up in the bedroom in the house, and that's the same bed set that was in the shed for the initial inspection.
So wait, help me understand. So there's a house and a structure.
Yeah, there's a mobile home on the property and there's a shed, and we've been getting complaints of her living in the shed with her children. And a lot of dogs.
Yeah, I mean, All right, I understand the code section. What's the county's recommendation?
The Citrus County Code Compliance Division respectfully requests that the special master assess a fine in the amount of the administrative costs associated to this investigation, which is $259.10. And, yeah.
Okay, that's where we'll start. I'll find that a violation did occur, and as a result of the violation, honestly, it was a repeat violation. It happened multiple times, as shown by the evidence. I'll assess the administrative costs that I'm permitted to under the Citrus County Code.
Thank you.
All right.
Next case on today's agenda, Ava J Carter, case number 2024-1118, Code Officer Julie Wilkinson, page 6 of your agenda.
Okay. Julie Wilkinson, Citrus County Co-Compliance Officer. This is case number 24-01118, excessive growth and accumulation of vegetation. A violation of Chapter 20, Article 6, Section 20-60 of the Citrus County Code of Ordinances. The address is 5596 West Thomas Court in Homosassa. The property owner is Ava J Carter. I have good service via posting the notice of hearing at the property and at the Lecanto Government Building. I would like to authenticate the following documents and request they be admitted into evidence. Exhibit A, photos taken during initial inspection on June 24th, 2024, photos from a corrective action inspection on July 10th, 2024, and photos from my final inspection on August 20th, 2024. Exhibit B, a copy of the notice of violation, a copy of the notice of hearing, a copy of the general pre-hearing order, a copy of the notice of hearing posted at the property, and a copy of the posting affidavit.
Okay, without objection, exhibits A and B are admitted as evidence. Thank you. What's the county's recommendation?
$100 a day along with the administrative costs, begin after the date you deem sufficient.
Okay. I think this is sufficient evidence already to determine that a violation has occurred. And I'm sorry, you said $100 a day?
Yes, sir.
Okay. I'll grant. Did you have contact with the owner?
No, I've talked with several of the neighbors, and they said that the property has been vacant for years, and they've lost contact with the owner, so they're not even sure if.
Okay. All right.
Yeah.
Then I'll grant 14 days to bring it into compliance. If it's not brought into compliance as ordered, $100 a day.
Thank you.
Next case, Faith Baptist Church of Homosassa Springs Incorporated, case number 2024-670, Code Officer Julie Wilkinson, page 7 of your agenda.
Are you looking for replacements for Ms. Becker right now?
Yes. Well, we've already went through that process.
Oh, really?
Yes.
Wow.
They couldn't find anybody who could replace
That's
No,
right.
they
That's right.
Julie Wilkinson, Citrus County Code Compliance Officer. This is case number 24-00670. Excessive growth and accumulation of vegetation, a violation of Chapter 20, Article 6, Section 20-60 of the Citrus County Code of Ordinances. The address is 6918 South Spartan Avenue in Homosassa. The property owner is Faith Baptist Church of Homosassa Springs, INC. I have good service via signed certified mail return receipt. I would like to authenticate the following documents and request that be admitted into evidence. Exhibit A, photos taken during initial inspection on April 10th, 2024. Photos from a corrective action inspection on June 27th, 2024. And photos from my final inspection conducted on August 20th, 2024. Exhibit B, a copy of the notices of violation, a copy of the notices of hearing, a copy of the general pre-hearing order, a copy of the signed certified mail return receipt.
Exhibits A and B are admitted as evidence. Thank you. Did you have other cases on this property?
No, sir.
Okay. All right, I'll let you present this one. Yeah.
On April 10th, 2024, I conducted an initial inspection and observed the property to be in violation. There was a large pile of tree debris collected along the property line. On April 12th, 2024, a notice of violation was issued for excessive growth and accumulation of vegetation, which is a violation of the Citrus County Code of Ordinances. On June 27th, 2024, I conducted a corrective action inspection and observed that the pile of tree debris remained on the property. I have not had contact with the property owner other than a voicemail requesting an inspection. I have made multiple calls and left multiple voicemails, but was never able to speak with anyone. As of my final inspection on August 20th, 2024, the property remains in violation.
When was the voicemail received?
One second. In June.
Okay. Did they say they wanted an inspection in order to establish that there was no violation, or they brought it into compliance?
I don't recall. I just, based on my log notes, I just put, I conduct an inspection at the request of the church.
Okay. What's the county's recommendation?
$100 a day along with the administrative costs begin after the day you deem sufficient.
All right, I'll grant 30 days, and it'll be $100 a day.
Thank you.
Thank you.
Next case, George Finny, case number 2024-1220, Code Officer J.C. Charlton, page 8 of your agenda. J.C. Charlton, Citrus County Code Compliance Officer. This is case number CE 2024-1220, accumulation of junk and debris, a violation of Chapter 20, Article 3, Section 20-31A of the Citrus County Code of Ordinances. The address is 36 South Columbus Street in Beverly Hills. Property owner George Finny. Good service via posting the property and at the Lecanto Government Building. I would like to authenticate the following documents and request to be admitted into evidence. Photos taken during the initial inspection on July 5th and corrective action inspection on July 23rd, follow-up inspection on August 7th, and my final inspection on August 19th, all of 2024. Exhibit B, notice of violation, notice of hearing, a copy of the pre-hearing order, photos of the posted property, and a copy of the posting affidavit I completed.
Okay. Exhibits A and B are admitted. Thank you.
Initial inspection was conducted on July 5th of 2024. Photos depict discarded items on the back of a truck and auto parts and debris on the right side of the home. I have had contact with the property. He responded to me posting the property with the notice of hearing. He stated he is out of town until late October, but he will resolve the violation. As of my final inspection on August 19th of 2024, the property remains in violation.
I mean, it's really not that much. It is a violation, but, okay, what's the county's recommendation?
Citrus County Code Compliance Division respectfully requests that Special Master assess a fine of $50 per day along with administrative costs to begin after the date you deem sufficient to abate the violation. This amount was selected based on the property owners once they were advised of the violation. This amount is appropriately given in the severity of the violations and respondents' actions to the violation. Would also ask the Special Master additionally find that it's respondent's responsibility to contact Code Compliance Division to allow for reinspection.
I'll grant 30 days, and if it's not brought into compliance as ordered, $50 a day.
Thank you. Oh, I'm up again. I'll speak there. Yeah, if you want. Next case on today's agenda is Jennifer Lynn Hall, case number 2024-1167, Code Officer J.C. Charlton. J.C. Charlton, Citrus County Code Compliance Officer. This is case number 2024-1167, accumulation of junk and debris, Chapter 20, Article 3, Section 20-31A of the Citrus County Code of Ordinances. The address is 333 South Jefferson Street, Beverly Hills, Florida. Property owner Jennifer Lynn Hall. Good service via posting the property and like the Canto Government Building. I would like to authenticate the following documents and request to be admitted into evidence. Exhibit A, photos taken during the initial inspection on July 2nd, corrective action inspection on July 17th, and follow-up inspection on August 7th. My final inspection on August 19th, all of 2024. The notice of violation, notice of hearing, and copy of the pre-hearing order and photos of the posted property and the posting affidavit I completed.
All right. Without objection, exhibits A and B are evidence.
Initial inspection was conducted on July 2nd of 2024. Photos depict tree debris on the property. Follow-up inspection was conducted on August 2nd. Tree debris remained on the property. I had contact with the property owner on yesterday. Not the property owner, the property owner's husband. He stated that they are working on removing debris, and based on my last inspection on August 19th, a lot of debris was removed on the side of the home. The remaining debris is on the front lawn. They stated they would remove that as well.
Just want to make sure I understand the case. This is a junk debris rubbish case, and on the pictures from August 19th, there's a bunch of garbage bags. Is that a violation?
The garbage bags was the tree debris that was cut up and put in bags.
Yeah.
Yes, he would need to remove those.
But the bags themselves are actually a violation?
They could be if they remain there, because it still would become a breeding ground.
And then the only other thing, at least according to the photos, from what I can see, is the stump debris from the front yard?
Yes, sir.
Okay, okay, what's the county's recommendation?
Citrus County Code Compliance Division respectfully requests Special Master assess a fine of $50 per day, along with the administrative costs to begin after the date you deem sufficient to abate this violation. This amount was selected based on the actions of the property owners once they were advised of the violation. This amount is appropriately given to the severity of the violation and respondents' actions relative to this violation. We would also ask the Special Master additionally find that it's respondents' responsibility to contact the Code Compliance Division to allow for reinspection.
I'm just thinking about the front part. I agree about the bags.
Mm-hmm.
Do you think that one stump is an accumulation of vegetative matter, or that it satisfies the statute? I'm just curious.
Tree debris.
Yeah, debris. But accumulation of debris. Well, look, because a violations occur, I will find that a violation has occurred. I'll grant 14 days to bring it into compliance. If it's not brought into compliance in 14 days, $50 a day.
Thank you.
Okay.
The next three cases on the agenda, Masana E Kinzer, case numbers 2024-1206, 1207, and 1208. Property address is 64 South Tyler Street in Beverly Hills. J.C. Charlton is the code officer, pages 15, 16, and 17 of your agenda.
And these are all good to run them all together, right? J.C. Charlton, Citrus County Code Compliance Officer. It's case numbers 2024-1206, 2024-1207, 2024-1208. Accumulation of junk and debris, a violation of Chapter 20, Article 3, Section 20-31A. Unlicensed inoperable vehicle, violation of Chapter 20, Article 4, Section 21-41. Excessive growth and accumulation of vegetation, a violation of Chapter 20, Article 6, Section 20-61 of all of the Citrus County Code of Ordinances. Property, the address is 64 South Tyler Street. Property owner, Masana E Kinzer. Good service via posting of property and at the Lecanto Government Building. I would like to authenticate the following documents and request that they be admitted into evidence. Photos taken during initial inspection on July 2nd. Corrective action inspection on July 17th. Follow-up inspection on August 7th. And my final inspection on August 19th, 2024. Exhibit B, the notice of violation, notice of hearing, copy of the pre-hearing orders, photos of the posted property, and a copy of the posting affidavit I completed.
Okay, without objection, all of the proposed exhibits are evidence.
An initial inspection was conducted on July 2nd. The photos depict violations of junk and debris, unlicensed vehicle, overgrown lawn in the front and the back. I have had no contact with the property owner. As of my final inspection on August 19th of 2024, the property remains in violation.
Do you know if the property owner is still around, or do you have any?
I don't know.
Okay. There does appear to be a violation in each of the three cases. What's the county's recommendation?
$100 a day per violation.
Okay. I find that the violation has occurred in all three cases, and I will grant in the 18-inch overgrown grass case is what I'll call it, but 24-1208, 14 days to bring it into compliance, and $100 a day if it's not brought into compliance as ordered. And same for the inoperable unlicensed vehicle, 14 days, $100. And for the junk, 30 days and $100 a day.
Thank you.
Thanks.
Next case on the day's agenda is Sandra Kirchain and Susan G. Baldry and Harry Baldry. Case number 2024-1052. Code Officer Julie Wilkinson, page 18 of your agenda.
Julie Wilkinson, Citrus County Code Compliance Officer. This is case number 2401052. Accumulation of junk and debris, a violation of Chapter 20, Article 3, Section 20-31A of the Citrus County Code of Ordinances. The address is 5445 West Starburst Lane in Homosassa. The property owner is Sandra Kirchain, Susan G. and Harry Baldry. I have good service via posting the notice of hearing at the property and at the Lecanto Government Building. I would like to authenticate the following documents and request it be admitted into evidence. Exhibit A, photos taken during initial inspection on June 4th, 2024. Photos from a corrective action inspection on June 24th, 2024. and photos for my final inspection conducted on August 20th, 2024. Exhibit B, a copy of the notice of violation, a copy of the notice of hearing, a copy of the general pre-hearing order, photo of the notice of hearing posted at the property, and a copy of the posting affidavit.
All right, without objection, the exhibits are evidence. And to be candid, I think that it's pretty well established by your photos. What is your recommendation?
$100 a day, along with the administrative costs.
Have you had contact with the owner?
No.
Okay. All right, then I will grant. I think I got to start cracking down a little more on these. I'll do 14 days, and how much per day is the county's recommendation?
$100 a day.
And $100 a day.
Thank you.
Next case, Barbara J Murdoch, case number 2024-1105, Code Officer Cody McGuire, page 26 of your agenda.
Cody McGuire, Citrus County Code Compliance Officer, case number 2024-01105, unlicensed inoperable vehicle, a violation of Chapter 20, Article 6, Section 20-41 of the Citrus County Code of Ordinances. Property owner, or address is 9018 West Lakeview Court, Crystal River. Property owner is Barbara J Murdoch. Good service, signed, certified mail return receipt, and posting at the Canto Government Building. I'd like to authenticate the following documents and request they be admitted into evidence. Exhibit A is photos taken during initial inspection on June 20th, 2024, corrective action inspection on July 23rd, 2024, and photos of my final inspection on August 20th, 2024. Exhibit B is a copy of the notice of violation, copy of the notice of hearing, copy of the signed certified mail return receipt, and a pre-hearing order.
Without objection, what's been proposed as exhibits A and B are evidence. And is it just this one?
There's a black Super Duty that's in the back as well.
Okay.
Are you talking about the RV?
Yeah.
Okay, yes, sir. There's two vehicles.
Oh, there's two, okay. Oh, I see it. What? Is the other one unregistered?
The Ohio plates?
No, the black truck.
It expired in 2023.
Okay. How do you know that?
I was able to see it from the neighboring property.
Cody, Mr. McGuire, can you come here real quick?
Yes, sir.
I just want to show you. So I'm going to show you 1017. That's the. What does that look like to you? What is that? That's the expiration tag.
I see 11, but that's all I see.
All right. You don't see what the year is?
No, but I do remember it being 2023.
Okay. I mean, I see it differently.
Okay.
I do. Is this your only photo? It's
so.
zoomed in. I mean, I don't think there's any argument about the white one. Let me see. Man, I'm trying hard to see the three, Mr. McGuire. I really am. It really looks more like a 4 to me. And your photos don't lie. But I wish it was a little bit closer, maybe, just to resolve it. Could I get a second pair? Is there anyone else interested in being a witness or taking a look at it?
JC, you're the supervisor.
Yeah, I mean, I'm just
can't be a
curious.
witness.
No, I let me know what you think. I don't know if I'm. It is hard to see, but you agree with me? Okay, all right. So, Mr. McGuire, I just think you need to get a better lens on that camera. That's just my take on it.
It's in the works.
That's my take on it. It is a little blurry. I'm going to find that a violation has occurred on, I guess, the camper, whatever. What's the county's recommendation?
The county's recommendation is $100 per day plus administrative cost.
Okay. I'll grant 30 days, and I'm so sorry. I know you literally just said it, but this is the time when I start to get tired. $100 a day?
Yes, sir.
All right, $100 a day. Thanks.
Thank you.
Next case, Patricia Martin and Angela N. et al. Case number 2024-168, Code Officer Julie Wilkinson, page 27 of your agenda.
Julie Wilkinson, Citrus County Code Compliance Officer, case number 2400168. Accumulation of junk and debris, a violation of Chapter 20, Article 3, Section 20-31A of the Citrus County Code of Ordinances. The address is 5415 West Starburst Lane in Homosassa. The property owner is Patricia Scholl, Angela N. Martin, Sandra LaBranch, Alan J. and Joseph Kirchain. I have good service via posting the notice of hearing at the property and at the Lecanto Government Building.
Wait, Kirchain? What Kirchain?
It's a next door property to the last case item, and I think they're families.
Oh, okay.
Possibly.
Gotcha. Interesting.
Mm-hmm. And junk moves from one to the other.
Interesting. All right.
I have good service via posting the notice of hearing at the property and at the Lecanto Government Building. I would like to authenticate the following documents and request they be admitted into evidence. Exhibit A, photos taken during an initial inspection on February 2nd, 2024. A corrective action inspection on June 26th, 2024. And photos from my final inspection conducted on August 20th, 2024. Exhibit B, a copy of the notice of violation, a copy of the notice of hearing, a copy of the general pre-hearing order, photo of the notice of hearing posted at the property, and a copy of the posting affidavit.
All right. Exhibits A and B are evidence. Again, I think the photos do tell the tale. Seems clear that these photos taken at the property show junkyard conditions. What is your recommendation?
$150 per day along with the administrative costs.
Okay. Now, I'm just curious, as a logistical matter.
Yes, sir.
It says in the affidavit of Julie Wilkinson, on August 8th, 2024, a copy of the notice hearing was posted due to the inability to serve the notice of hearing via certified mail or hand delivery, August 8th. You tried sending by certified mail?
Yes, sir.
Okay. But on the agenda, it says it was advertised August 10th. So what is the difference? Like, why August 10th would it say it's advertised?
Well, I don't know what that means. All I know is that I posted the paper.
Is it put in the paper or?
No.
Oh. Okay.
Yes.
Okay. Okay. All right. I just never saw that before. So, all right. Jeez. All right. And this has been pending a while.
Yes, it has. Initially, they were cleaning it up, and then it stopped, and then I saw some of the junk from that property move next door, like the mattress that was on top of the shed is now next door, next to the boat. So that's why I've also given this one $150, not $100.
Okay, then grant 14 days, and it'll be $150 a day.
Thank you.
Thanks.
Next case on the day's agenda, Dale Stegler, case number
Oh, wow.
2024. 1000, Code Officer Cody McGuire, page 28 of your agenda.
Have you ever heard of the Barefoot Bandit? No. There was like this 17-year-old kid who was stealing planes, and they called him the Barefoot Bandit because they would find his feet in like the snow.
Yeah.
And this is just my perspective, but I used to really root for him. Like, man, I hope he gets away with it. I mean, how can you not root for the barefoot bandit? But of course, like all misdemeanor masterminds, he was ultimately caught. And I'm not saying I'm rooting for Miss Stegler, but she finds a way back. All right. What do you got?
We got a repeat violation. Cody McGuire, Citrus County Code Compliance Officer. This is a repeat violation initially observed on June 24th, 2024. The address of the violation is 6901 West Arlington Place, Homosassa, Florida. Case number 2024-01000. Accumulation of junk and debris. A violation of Chapter 20, Article 3, Section 20-31A of the Citrus County Code of Ordinances. Property owners Crystal Stegler has been previously found guilty of the same violation at 6881 West Arlington on January 18th, 2023.
6881?
6881, yes,
Okay.
sir. On January 18th, 2023, case number was 2177612 with $0 in imposed fines. This case was abated on March 27th of 2023. I have good service, signed certified mail return receipt, and posting at the Candido Government Building. I'd like to authenticate the following documents and request they be admitted into evidence. Exhibit A is the findings of facts in order acknowledging compliance from the previous case 2177612. Exhibit B is photos taken during my initial inspection on June 24th, 2024. Photos I've taken during subsequent inspections on July 1st, 11th, 15th, 19th, 24th, August 1st, 9th, 16th, and then a pre-hearing inspection on 20th. Exhibit C is a copy of the notice of violation and hearing sent to Christelle Stegler, a photo of the notice of violation, and a photos of the notice of violation and hearing posted on the property, and a copy of the general pre-hearing order.
Okay. Exhibits A, B, and C are admitted as evidence. And have you had contact with the owner?
No, sir.
Okay. It says in the prior case that it was Code Officer J.C. Charlton. How
Yes,
long
sir.
have you been where you are now?
Maybe two and a half, 3 years.
But you were the code officer on this case?
Mm-hmm.
Huh. Okay.
Yeah, I remember.
Well, I'm sure you do. I just, I thought you were doing that
no,
longer,
just-
so I'm surprised.
When I started, he was interim.
Right.
Yeah.
We still had cases
And-
assigned to him. It's
I
been
see.
over 2
Okay.
years now, so.
That's what I was gonna say. I thought it'd been a little longer. All right. Wow. I mean, it's not just a minor violation. It's, I don't understand this. Has it abated as of today?
No, sir. As of yesterday, it has not.
Okay.
The majority of the photos that you're looking at now are probably the vegetative matter on the fence.
Well, there's some interesting rock structures. Do you know what I'm talking about? What are they?
Your guess is as good as mine.
Okay.
Yeah.
It could be art. I mean, yeah, maybe they've been scrutinizing some of my orders on art too closely. Okay. So it's hard for me to tell, but I'm looking through this. Did she make improvement?
So we were able to have access to a neighboring property, and then whenever we were denied that access is whenever those photos were unable to be taken.
I see. So you you got access from a neighbor, and then the neighbor started denying access?
Mm-hmm.
Is her property the one with beyond the red fence with like the palm, the vegetative matter? Like, where is her property here?
Yes, sir. So her property's inside that fence.
Okay.
That's that's the side of her property
Mhm.
from a neighboring property.
What's your recommendation?
The Citrus County Code Compliance Division respectfully requests that the special master assesses a fine of $250 a day with administrative costs to begin on the date of the posting of the property, which was June 25th, 2024, and continue until August 20th, 2024. That would be 57 days at $250 per day, totaling $14,250, and a fine of $500 a day from the day forward until the violation is abated. We would also ask the special master find that it's the respondent's responsibility to notify the Code Compliance Division when the violation has been abated in order to allow for reinspection. But I would love to be able to see inside that fence as well.
I see. Okay. Well, I'll find that it is a repeat violation. I'll assess $250 a day from June 25th until, I think you said August 20th.
Yes, sir.
Okay. And from it would be $500 a day from here on until abated, and I will include in the order, that you have to be able to inspect in order to determine whether it's come into compliance or not.
Yes, sir.
Okay. Anything else on that case? All right. Thank you.
Thank you.
Last case today, Christina Townsen, case number 2024-1296, Code Officer Julie Wilkinson, page 30 of your agenda.
Julie Wilkinson, Citrus County Code Compliance Officer. This is a repeat violation. Initially observed on July 18th, 2024. The address of the violation is 6359 West Pershing Drive, Homosassa, Florida. Case number is 24-01296, accumulation of junk and debris, a violation of Chapter 20, Article 3, Section 20-31A of the Citrus County Code of Ordinances. The property owner is Christina Townsen. She has previously been found guilty of the same violation at the same location on June 22nd, 2023, and that case number is 218-4633 with $0 in imposed fines. That case was abated on July 26, 2023. I have good service via posting of the property, posting of the property and at the Lecanto Government Building. I would like to authenticate the following documents and request they be admitted into evidence. Exhibit A, findings of fact and order acknowledging compliance from previous case number 218-4633. Exhibit B, photos taken during an initial inspection on July 18th, 2024, and photos I took during subsequent inspections on July 24th, August 2nd, 9th, 16th, and photos from my final inspection on August 20th, 2024. Exhibit C, a copy of the repeat notice of violation and hearing sent to Christina Townsen, a copy of the notice of violation and hearing posted at the property, a copy of the general pre-hearing order, and a copy of the posting affidavit.
Exhibits A, B, and C are admitted as evidence. Thank you. Go ahead.
Yes, sir. I conducted my initial inspection on July 18th, 2024, and observed appliances, a sink, furniture, miscellaneous junk and debris on the property. I posted the repeat notice of violation and notice of hearing at the property on July 18th, 2024. During subsequent inspections on July 24th, August 2nd, 9th, 16th, and the final inspection on August 20th, 2024, the property remained in violation. I have had contact with the property owner, and she's aware of what needs to be done. She's currently in the middle of cleaning up another property that's in violation. She'll get to it when she gets to it, basically, is what she said.
Okay. What's the county's recommendation?
The Citrus County Code Compliance Division respectfully requests that the special master assess a fine of $150 per day, along with the administrative costs to begin on the date of the posting of the property, which is July 18th, 2024, and continue until August 20th, 2024. That would be 34 days at $150 per day, totaling $5,100, and a fine of $250 per day from this day forward until the violation is abated. We would also ask the special master find that it is the respondent's responsibility to notify Code Compliance Division when the violation has been abated in order to allow for reinspection.
Okay. I will so order that from July 18th to August 20th, $150 a day, finding that this is a repeat violation. From today forward, there will be a fine of $250 a day to the extent that it is not abated. And I incorporate everything else as a standard order provision.
Thank you.
All right, so that was the last case on the agenda.
Yes, sir.
Is there anything else to be taken up?
I don't have
Okay. I don't think I have anything. All right, the time is about 12:13. This hearing is adjourned.